Good afternoon, ladies and gentlemen. The afternoon section shall commence soon, so please be seated. A gentle reminder, please kindly switch your mobile phones or any electronic devices to silent mode. Once again, the Congress will be conducted in English and Cantonese with separate channels for simultaneous interpretation in Cantonese, 普通话, and English. Please tune to Channel 1 for English, Channel 2 for Cantonese, and Channel 3 for 普通话. You may pick up your headsets, SI headsets, at the entrance of this room. If you wish to have a SI headset, please raise your hand and our event team will pass one to you. For online participants, you may choose your preferred language as shown on the screen by clicking the channel directly. You're recommended to use headphones for better sound experience. Ladies and gentlemen, our afternoon section will commence now, so please be seated. Thank you. Ladies and gentlemen, good afternoon. Welcome back to the afternoon section of the Rule of Law Congress, Rule of Law and Justice for All. On stage, we're now... Please type your questions in the chat box at the bottom of the screen. Without further ado, our speakers are now ready, so I would like to pass the time and stage to our moderator. Mr. Dos, over to you.
I want to welcome everyone to the second panel session of today. The title is Access to Justice for All, Diversified Dispute Resolution Mechanism. And I'm thrilled to be joined by a very distinguished panel. I'm sure most of you are actually familiar with our speakers today, and you'll forgive me for keeping the introduction to relatively short. In the order of presentation, can I first of all introduce Mr. Rimsky-Yuen, SC. As most of you know, he's the chair of the Hong Kong Mediation and Accreditation Association. He is also the co-chairperson of the HKIAC, a practicing senior counsel, arbitrator, and mediator. And a lot of you will remember Rimsky as our former Secretary for Justice from 2012 to 2018. The second speaker is Mr. Justice Robert Tang, currently a non-permanent judge of our Court of Final Appeal and one of the most popular arbitrators in our jurisdiction. A lot of you in this room, in fact, looking around, I think most of you are practicing lawyers in this jurisdiction, and I'm sure most of you would have read and have cited Robert's judgment in your practice. Robert was a member of the Hong Kong Bar since 1970. He was appointed Queen's Counsel in 1986. He joined the bench in 2004 as a judge of the Court of First Instance and was promoted to the Court of Appeal in the following year. He joined the Court of Final Appeal in 2012 and retired as a full-time judge in 2018. Now, last but not least, of course, we have the rows between the phones, Ms. Winnie Tam, SC. Winnie is also a practicing senior counsel, and in addition to being our top intellectual property specialist, Winnie is a recorder of the High Court. She sits as an arbitrator in a wide range of commercial cases. And then on top of all that and outside the law, Winnie is also the chairperson of the Hong Kong Palace Museum Board, and she also chairs the Communication Authority. We can all ask her later where does she find time for all that. Finally, it gives me great pleasure also in that all three of them were my predecessor, and they were all chairmen of the Hong Kong Bar Association. They left very big shoes for myself to fill. Returning to the topic today, access to justice. Provision of affordable and effective and timely legal and dispute resolution service is certainly an important component when we consider the rule of law. As an international dispute resolution hub and an IFC, Hong Kong has really got a diverse dispute resolution mechanism catering for the needs of our citizens and also our friends from abroad. In fact, I was inspired by Professor Tirado when we spoke about food in Hong Kong the other night when we were at the Legal Week races. But I was just reminded by Secretary for Justice that he actually used the same analogy this morning. So at the risk of being accused of plagiarism, I will stick to my point. What we talked about was how he loved eating in Hong Kong and that there's really something for everyone, from Michelin star cuisine to the authentic hawker stores you can find around town offering cheap and tasty food. There's really something for everyone. And like the Secretary of Justice, I do think we can say the same thing about dispute resolution services here. No matter whether you have a high-value arbitration or litigation, or just a small dispute between neighbors, you'll be able to find something that would ensure that your dispute is resolved in an economic and proportionate manner. So on that note, and without further ado, I will first invite Rimsky, who will give us an overview on the different options in Hong Kong. Thank you very much, Rimsky.
Secretary of Justice, distinguished guests, ladies and gentlemen, good afternoon. First of all, may I express my gratitude to the Department of Justice for giving me this opportunity to share with you some of my personal thoughts on the topic chosen for this session, namely, access to justice for all, diversified dispute resolution mechanism. As the first panelist, I intend to give you a snapshot of the situation in Hong Kong. The other two panelists, Robert and Winnie, will focus on individual areas relevant to the topic in question. It has been generally accepted that the rule of law in Hong Kong is a cornerstone of Hong Kong's success, especially in respect of her role as an international city and in particular as an international financial center. Today, of course, is not the occasion to embark upon a detailed jurisprudential discussions of the concept of the rule of law. However, for present purposes, one point is sure. Access to justice and dispute resolution are two of the important and interrelated elements of the overall concept of the rule of law. Put shortly, even the best legal and judicial system would become meaningless if legal disputes cannot be resolved fairly and effectively, or that parties who believed their legal rights have been infringed cannot have access to an effective dispute resolution regime in one way or another to satisfactorily enforce their legal rights. In the well-known text of the rule of law by Lord Bingham, the learned judge explained this concept as follows, and if I may quote, "It would seem to be an obvious implication of the principle that everyone is bound by and entitled to the protection of the law, that people should be able, in the last resort, to go to court to have their civil rights and claims determined. An unenforceable right or claim is a thing of little value to anyone." End of quote. In Hong Kong, the right to access to justice is constitutionally guaranteed under Article 35 of our Basic Law, which reads as follows. Hong Kong residents shall have the right to confidential legal advice, access to the court, choice of lawyers for timely protection of their lawful rights and interests, or for representation in the courts and to judicial remedies. Hong Kong residents shall have the right to institute legal proceedings in the courts against the acts of the executive authorities and their personnel. Article 39 of our Basic Law also provides, among others, that the provisions of the International Covenant on Civil and Political Rights as applied to Hong Kong shall remain in force and shall be implemented through the laws of Hong Kong. In this regard, Articles 10 and 11 of the Hong Kong Bills of Rights, which deal with equality before courts and right to fair and public hearing, as well as right of persons charged with or convicted of criminal offense respectively, which are set out in Part 2 of the Hong Kong Bills of Rights Ordinance, are also important provisions in the context of access to justice. In addition, access to justice is protected under common law. Indeed, the common law right of access to court has often been described as a constitutional right. Among others, such right is reflected in the well-established common law presumption of legislative intent that access to the court in respect of justiciable issues is not to be denied save by clear language. Besides, the ability of an individual to bring prosecution is another facet of this right of access to court. Nevertheless, access to justice is not and should not be confined to access to courts, which resolve civil disputes through conventional court litigation. An effective dispute resolution system, other than that of the court, is equally important. Indeed, as early as April 1976, Professor Frank Zender of Harvard Law School started to articulate the concept of multi-door courthouse in a conference concerning the administration of justice. Looking at matters as they now stand, I would venture to suggest that Hong Kong's dispute resolution landscape offers a modified and enhanced version of Professor Zender's idea of multi-door courthouse. The key reasons, if I may venture to suggest, include, first of all, the judicial system of Hong Kong is there to act as the ultimate gatekeeper of dispute resolution, and thus also the ultimate gatekeeper of justice. Second, in addition to court litigation, there are various other means of dispute resolution available for the parties to choose. Key examples include arbitration, mediation, and adjudication. Third, the question of cause is one of the key considerations in dispute resolution. The system of legal aid in Hong Kong and also the recent development concerning the funding of arbitration and mediation in Hong Kong are effective means to uphold the concept of equality before the law as well as to ensure access to justice. For present purposes, I would briefly deal with these three aspects. Starting, if I may, with the court system. Article 19 of our Basic Law stipulates that the Hong Kong SAR shall be vested with independent judicial power, including that of final adjudication. It goes on to provide that the courts of the Hong Kong SAR shall have jurisdiction over all cases in the region, except that the restrictions on their jurisdictions imposed by the legal system and principles previously enforced in Hong Kong shall be maintained. Section 4 of the Basic Law specifically deals with the judiciary. A few of the provisions contained in Section 4 merit attention. Article 80 stipulates that the courts of the Hong Kong SAR at all levels shall be the judiciary of the region, exercising the judicial power of the region. Closely related to this is Article 85, which provides that the courts of the Hong Kong SAR shall exercise judicial power independently, free from any interference. Another provision of importance in the Basic Law is Article 82, which stipulates that power of final adjudication shall be vested in the Court of Final Appeal, which may, as required, invite judges from other common law jurisdictions to sit on the Court of Final Appeal. In recent years, the arrangement under Article 82 concerning overseas non-permanent judges of the Court of Final Appeal has attracted certain discussions. Some discussions go beyond the Court of Final Appeal and touches on nationality of our judges. Since Article 90 of the Basic Law only imposes nationality restrictions on the Chief Justice of the Court of Final Appeal and the Chief Judge of the High Court. Healthy discussions on topics of public importance is a reflection of, and indeed, the aim of any democratic and open society. Constructive discussions can bring about desirable changes which can make our society a progressive one. However, in discussing matters concerning the judiciary, especially those that are governed by the solemn provisions of the Basic Law, one should perhaps bear in mind that those relevant provisions in the Basic Law represent the result of serious and lengthy discussions during the drafting of the Basic Law. They were included in the Basic Law for good reasons. In particular, the participation of overseas judges in our Court of Final Appeal has been viewed positively by the international business community. It also helps to ensure the continuous presence of international expertise of the highest caliber, as well as the facilitation of cross-fertilization in the development of Hong Kong's common law. One international trend that may be worth mentioning in this regard is the growing popularity of international commercial courts in different jurisdictions. In some of these international commercial courts, such as the one in Singapore, a similar formula is adopted in that foreign judges are invited to sit in their international commercial court. With the constitutional safeguard and the professionalism of our judges, court litigation continues to be an effective means of access to justice in Hong Kong. Moving on, if I may, to other forms of dispute resolution. Arbitration is, of course, one of the most natural options that springs to one's mind. Unlike court litigation, the mandate of the arbitral tribunal is derived from the parties' arbitration agreement. The concept of party autonomy is one of the key pillars of arbitration. Freedom of choice over arbitrators and also procedure, confidentiality, and ease of enforcement of arbitral awards pursuant to the New York Convention are the key factors which explain the popularity of international arbitration. They are also the reasons why international arbitration provides a robust alternative to court litigation in terms of access to justice. The development and promotion of arbitration in Hong Kong has a long history. Since the setting up of the Hong Kong International Arbitration Center in the 1980s, arbitration, whether domestic or especially international, has gathered momentum in Hong Kong. Arbitration is not conducted in a vacuum. Supporting legislation is of paramount importance. That's why the Department of Justice continuously keeps a close eye on the development in the arbitration landscape and has introduced significant changes to the arbitration ordinance in the past 2 decades so as to ensure that the arbitration legislation in Hong Kong can meet the needs of our end users. Further, there is the support of the arbitration-friendly judiciary. Against such background, coupled with the hard work of the arbitration community in Hong Kong, arbitration has provided an effective means of access to justice. especially in the commercial context, which is another pillar which supports Hong Kong's status as an international financial center. Let me move on to mediation. In the 2014 mediation conference held by the Department of Justice, our then Chief Justice, that is the Honorable Chief Justice Geoffrey Ma, described mediation as follows. He said this: "I have had debates with fellow judges over whether mediation, like arbitration, can be said to be a part of the administration of justice. This is largely a sterile debate over whether the term the administration of justice is confined to what the courts do and the role of judges. For me, the administration of justice includes, as an integral activity, the resolution of disputes to arrive at a just, proper, and legally justifiable result. Mediation fits into this rubric." End of quote. Indeed, with the introduction of the mediation ordinance in Hong Kong and the subsequent apology legislation, together with the support of various mediation organizations and the dispute resolution community, the mediation landscape in Hong Kong has undergone fundamental changes in the past decade or so. In short, mediation is now another additional means of access to justice. Despite the absence of a top-down adjudication or ruling, the outcome of mediation in the form of an amicable settlement is often more receptive to the parties, as mediation can often achieve objectives that court litigation cannot. In the context of access to justice, another pertinent example perhaps is the security of payment in the construction context. The security of payment rules came into effect on the 23rd of February 2022. Cash flow has been described as the lifeblood of construction industry. The security of payment rules seeks to avoid blockage of payment or delay of payment as a result of disputes, which are not uncommon in the construction industry. The Hong Kong International Arbitration Center has since established the panel of adjudicators for the security of payment scheme and also a new set of rules so as to assist the implementation of these schemes. On the whole, there are different means of dispute resolution other than the conventional court litigation. These different means have their respective attractions. There is no one-size-fits-all solution in the context of dispute resolution. Just like our moderator Victor has mentioned, what is important is that the parties have the choice in front of them when they face disputes, just like when they face choice of restaurants, and can pick the option most suitable to the disputes they face after obtaining appropriate advices. That should be one of the ultimate aims of access to justice. Lastly, I wish to say a few words about funding of dispute resolution. Resolving legal dispute is often expensive. In the past, the court of a certain jurisdiction has been compared with the Ritz Hotel, with the connotation that unless you are rich, don't come in. In Hong Kong, various types of court litigation, such as matrimonial disputes, personal injury and fatal accidents litigation, are funded by legal aid. Compared with many other common law jurisdictions, the legal aid regime in Hong Kong is one of the most comprehensive regimes in the world. Besides, legal aid is not confined to court litigation. In appropriate cases, mediation is also covered. The funding of arbitration in Hong Kong has also undergone considerable changes. With the passing of the Arbitration and Mediation Legislation (third-party funding) Amendment Ordinance 2017, and also the recent arbitration and legal practitioner legislation outcome-related fee structures for arbitration Amendment Ordinance 2022, end users of arbitration and mediation can expect more flexibility in reaching a fee agreement with their legal teams. With such flexibility, access to justice is accordingly enhanced as well. To conclude, the choice of different means of dispute resolution coupled with the funding assistance or facilitation in one form or another are essential to maintain and consolidate access to justice. In Hong Kong, under the one country, two system, our legal and judiciary systems remain robust, and our dispute resolution landscape covering arbitration, mediation, and others continue to flourish. It remains for me to thank the organizer again for this opportunity and to wish all of you an enjoyable day. Thank you.
I want to thank Rimsky for the excellent overview on the different type of dispute resolution mechanism. Not only has he reminded us of the important constitutional safeguards under the Basic Law, covering topical issues such as our non-permanent judges in the Court of Final Appeal, he also gave us an overview of the hot topics, if I can use that term, insofar as mediation and arbitrations are concerned. So thank you very much, Rimsky. Without further ado, can I now hear from our next speaker, Mr. Justice Robert Tang, who will tell us a bit about how Hong Kong as a cosmopolitan, the role that we can play in the process. Thank you, Robert.
Secretary for Justice, distinguished guests, ladies and gentlemen. In President Xi Jinping's speech on the 25th anniversary of the establishment of the Hong Kong SAR, he called Hong Kong a cosmopolis. He said, as a cosmopolis, Hong Kong's vitality has impressed the world. In the original Chinese, he said, 香港作為國際大都會，勃勃生機，世界為之讚嘆. His description of Hong Kong as a cosmopolis is significant. According to the Collins English Dictionary, a cosmopolis is an internationally important city inhabited by many different peoples, reflecting a great variety of cultures, attitudes, etc. I believe this accurately describes Hong Kong and explains much of Hong Kong's success. Importantly, implicit in the description is the acceptance of and respect for different cultures, attitudes, etc., without which no city could truly be a cosmopolis. Elsewhere in his speech, President Xi talked about Hong Kong's status as an international financial, shipping, and trading center. And he said, quote, the central government fully supports Hong Kong in its effort to maintain its distinctive status and edges, to improve its presence as an international financial, shipping, and trading center, to keep its business environment free, open, and regulated, and to maintain the common law so as to expand and facilitate its exchanges with the world, unquote. The rule of law is the foundation of Hong Kong. The policy of one country, two systems not only entrenched the rule of law, it was designed with Hong Kong as a cosmopolis in mind, as the following provisions in the Basic Law amply demonstrate. First, Article 24, paragraphs 4 and 5, which provide that, quote, persons not of Chinese nationality who have entered Hong Kong with valid travel documents have ordinarily resided in Hong Kong for a continuous period of not less than 7 years and have taken Hong Kong as their place of permanent residence before and after the establishment of the HKSAR, unquote, and their children under the age of 18, or under the age of 21, also have the right of vote in Hong Kong. So long-term non-Chinese nationals who have taken Hong Kong as their home may become a Hong Kong resident with equal rights. Apart from a few positions, for example, that of the Chief Executive, the Chief Justice, the President of the Legislative Council, non-Chinese nationals can occupy important public positions. Few places in the world treat non-nationals so generously. Of course, unless non-nationals can feel at home here, they are unlikely to want to make Hong Kong their home. To make them feel at home and make Hong Kong their home, their different cultures, attitudes, etc., must be accepted and respected. I think Hong Kong has succeeded in that. We have a large number of non-Chinese nationals in Hong Kong who have made their homes here. According to statistics available to me, there are about 85,000 US nationals in Hong Kong as of 2018, and over 33,000 UK nationals in Hong Kong, of whom 19,000 odd are of European ethnicity, almost 7,000 Chinese, etc. As of 2014, approximately 300,000 Canadian citizens of all ethnic backgrounds live in Hong Kong. Many of these, I believe, were Hong Kong residents who had emigrated to Canada prior to 1997. The French consulate estimated that there are about 25,000 French citizens in Hong Kong. I do not have the figures, but the number of Hong Kong SAR's residents who have been educated outside of Hong Kong must be very large. There are also mainland residents in Hong Kong, many of whom have been educated overseas. Many of these people are in Hong Kong working for important local, mainland, or international businesses, without which Hong Kong would not be an international, commercial, financial, and trading center. These people also reflect the great variety of cultures and attitudes, etc., which are characteristic of a truly international city. It is this international mix which has given Hong Kong its strength. Secondly, Article 9 provides, in addition to the Chinese language, English may be used as an official language by the executive authorities, legislature, and judiciary of the Hong Kong SAR. Because of Article 9, all legislations in Hong Kong are enacted in both Chinese and English, and both versions are equally authentic. English has remained the dominant language in commerce, finance, and the law after 1997. Thirdly, Article 8, under which common law continues to be used in Hong Kong. These provisions are essential to Hong Kong's success. So too is an internationally accepted mechanism for dispute resolution. In any dispute, parties want an impartial, fair, and expert tribunal whose awards will be enforced expeditiously, fairly, and impartially. For this purpose, one needs experienced arbitrators and a strong legal profession. The importance of international arbitration to Hong Kong is obvious. That is why, as early as 1985, the Hong Kong International Arbitration Center, HKIAC, was established. I've been associated with it from its inception, and I hope I'll be forgiven if I do not mention the other arbitral bodies in Hong Kong. It was recognized from the beginning that although the Hong Kong government would provide HKIAC with the necessary seed money and its premises at a nominal rent, HKIAC would be totally independent. HKIAC has always been independent of government control. It is also truly international. It is there not to serve Hong Kong only or any sectorial interest. From its inception, HKIAC has been international with an international secretariat. Today, members of the secretariat come from different jurisdictions and speak, I'm told, 10 different languages. They are recruited on merit, regardless of their nationality. HKIAC's affairs are under the oversight of its council. There are currently 27 council members who come from 15 different countries or geographic areas. They hold passports of the United States, Hong Kong SAR, mainland China, the United Kingdom, France, Sweden, Germany, Singapore, New Zealand, Israel, Colombia, Australia, India, Korea, and Russia. It is truly international in its makeup. The current co-chairs are an ethnic Chinese HKSAR resident, Mr. Rimsky-Yun, and a non-ethnic Chinese US citizen. There are also over 550 persons on HKIAC's panel of arbitrators, and over 360 in its list of arbitrators. They hold different passports and are admitted to practice in a variety of jurisdictions, and they practice in many different geographical areas. In arbitrations administered by HKIAC, parties are most often represented by local and international firms. However, it is important to note that subject to the parties' agreement, the practice of arbitration, whether as arbitrator or as representative or advocate, is not confined to lawyers and does not require any formal qualification. Be that as it may, an international arbitration center requires a world-class, experienced, and independent legal profession. The Hong Kong SAR is well placed to handle international arbitration. There are over 12,000 solicitors in active practice or working in-house. They are made up of different nationalities. There are over 900 local law firms and over 80 foreign law firms in Hong Kong. Do not be misled by the word local. These local firms include many leading international firms from different common law countries, most noticeably from England and the United States. The foreign law firms, and there are about 1,400 registered foreign lawyers, are firms of foreign lawyers who offer services to the public as a practitioner of foreign law, and they include lawyers from many different jurisdictions. Hong Kong has also a very strong bar. There are over 1,600 barristers and over 100 senior barristers, senior counsel. The indigenous legal profession is independent and strong. They are well-trained and have honed their skill thanks to fierce international competition. Hong Kong is, together with London and Singapore, one of the most successful arbitration centers in the world. It is no coincidence that they have in common the common law system and English as the language of their law, as well as a world-class legal profession. But is Hong Kong slipping? I do not think we need to worry, provided Hong Kong can remain a cosmopolis. Indeed, there are signs that Hong Kong is recovering. For example, the figures up to October 2022 from the HKIC shows that the number of international arbitration in 2022 has far exceeded the figures for the same period in previous years. The Chief Executive has, in his policy speech, outlined measures designed to attract talents to Hong Kong. Hong Kong is indeed open for business. But these talents will want more than a good pay package. Hong Kong has to accept and respect the great variety of cultures and attitudes, etc., not only of the talents whom we wish to attract, but also to retain the many who are already here. If Hong Kong can remain a cosmopolis, I am confident that Hong Kong will continue to be a leading international arbitration center. Thank you.
Thank you very much, Robert. I'm sure the audience would like to join me in thanking you for reminding us the international nature of this jurisdiction. Of course, the place is only as good as its people. And looking at this crowd and looking at the guests that who joined us for lunch today, I think the international nature of the city has been demonstrated vividly. So thank you again, Robert. Now, last but not least, of course, Winnie will tell us a bit more about recent issues or topics in international arbitration and share with us some of her experience in sitting as an arbitrator and as advocate in arbitration.
Secretary for Justice, distinguished guests, fellow panelists, ladies and gentlemen, thank you very much for the Department of Justice for giving me this opportunity to join the Legal Week again and to share some of my thoughts. My talk today, I've actually prepared a few slides, but the slides are not terribly important. It is just intended to give a kind of outline. I have several points to make, and they are divided into three areas. First, the first point is perhaps already covered by other panelists. It is about the rise in popularity of arbitration for commercial disputes. The second point I would like to highlight is posed in the form of a question, and that is, does commercial arbitration promote access to justice, which is the theme, diversity, in this afternoon's panel. The third point I would like to cover is, how do we prepare for a better future? Diversity and inclusion in arbitration. And in that, I would like to cover 3 points, and that is diversity in the mode of dispute resolution. Secondly, diversity in arbitral panels, and diversity in fee structure, which is again a point which other panelists have touched on. The rise in popularity of international commercial arbitration is evidenced by rising numbers in every set of statistics that are published. Now, it is quite remarkable that in the past years, we have been following this Queen Mary College and White and Case international survey on arbitration. And of the 2021 figures that we have seen, 90% of respondents to the survey prefer arbitration to litigation, either as a standalone dispute resolution procedure or in conjunction with other alternative dispute resolution methods. And these other methods would include mediation and adjudication, as Rimsky has already averted to. This would be the highest proportion ever reached, I would say, and it would still be on the rise, I predict. And most remarkably, out of the top 3 most preferred centers of arbitration, 2 are in Asia. As I see it, it reflects the rise of Asia as economic forces in the world, and it also reflects the rise of Asian cities in terms of their companies being involved in international commercial activities, transactions, and hence disputes. Now, what does arbitration have to offer that is so attractive in commercial dispute resolution that 90% of people think that they would prefer international arbitration? Well, some of my fellow panelists have mentioned party autonomy. Party autonomy is, of course, the most attractive aspect because the parties who want their disputes resolved where they have a prior existing commercial relationship would like some control over the process. And often litigants in court proceedings do not find that they have a lot of control. Number one is that the judge's diary is not in your control. Recently, I've had a lengthy trial which was scheduled only to happen in the next month, and that is December, vacated altogether because the judge has been given other duties. That is unsatisfactory. I'm not blaming the judiciary for it because sometimes judges do get appointed to other roles which are important and which the rest of Hong Kong may have to pay a little price for. But that is what I refer to as a lack of control and hence increasing the lack of certainty in litigation. Next is to some degree of control over how many and who to appoint as the arbitral panel, and that is equivalent to the judge sitting as the adjudicator of the dispute. Now, of course, in a three-person panel, the party gets to choose his side of a designation of an arbitrator, and then the opponent gets to choose his designation of an arbitrator. And then the chair of the panel would sometimes be either chosen by the institution, the arbitral institution, or by the 2 designated co-arbitrators. In the case of a one-person panel, the arbitrator would be chosen by the institution very often, unless the disputing parties are able to agree. Now that, nevertheless, still offers some degree of control over how you would like the arbitral tribunal to be constituted, because the parties who are in the commercial transaction can very well agree in advance as to whether they want a 3-person panel or a sole arbitrator, or even in some commercial contracts I have seen, they've even agreed who to appoint in case they go into a dispute. Now this mode of the parties having put their minds to what will happen and what they want to happen, where before any dispute arises, is actually conducive to a smoother and easier resolution of disputes, hopefully, some of the times. Whereas parties in litigation are often engaged in more acrimonious exchanges and are more adversarial in nature. Next is the flexibility in procedure. That is often cited as another extremely attractive feature in arbitration. Whereas in court procedures, you have perhaps different chapters in the White Book, which we're familiar with, that would apply to different types of litigation. In arbitral procedures, the parties are able to put their heads together and decide right when they get into the arbitration, what sort of procedure they would like to adopt, bearing in mind the actual dispute that has arisen by then. And they work together, hopefully, together with the arbitrator or the arbitrating panel in arriving at the most suitable set of procedures to follow mutually. And that, again, is conducive to a sense of cooperation between the disputing parties. In technology cases, the flexibility in procedure has played a very strong role in ensuring that the dispute is resolved and adjudicated on efficiently with the involvement of experts and the exchanging of reports and experts putting their heads together in coming up with an area of agreement, identifying only a minor or limited areas of dispute for more efficient adjudication. Next is the finality element, of course, because if the parties agree to finally resolve their dispute through arbitration, the grounds upon which they could hope to reverse the outcome of the arbitration would be very, very limited. And that ensures that the outcome of the arbitration procedure is final, rather than the parties having to wait for a number of layers of court's rulings before they would finally know whether they have won the case or lost their case. Enforceability has been touched on, and that is often cited as a very attractive feature of international commercial arbitration, because then you can choose to enforce the award in any jurisdiction. Now, Hong Kong has an advantage because enforceability of our awards in China or our judgments in China has always been provided for in legislation, but that cannot be said of a lot of other jurisdictions. Next, I would like to examine whether commercial arbitration promote access to justice. Now, some who are not familiar with arbitration would ask, why do we choose to pay for a tribunal out of our own pockets if there is a justice system, i.e. the judiciary, where you can get your dispute resolved by a judge who does not expect you to pay him? Now, that is in fact a question to be considered together with all the other features that support international arbitration as a preferred mode of dispute resolution. Although you don't pay for the judge, you nevertheless pay for teams of lawyers, and you risk appellate procedures, which could take much longer than you wish. And the cost of court proceedings are often not fully recoverable, even though a party may have won the battle from beginning to end. There is next the question of the struggle for equality of arms. In international arbitration, as Robert has already averted to, there is a much wider pool of talent because the legal team that participate in the commercial arbitration process does not need to be qualified lawyers or does not need to be lawyers qualified in a particular jurisdiction or in the Hong Kong jurisdiction. You have a much wider pool of talents who you can refer to and seek help from to conduct the arbitration on your behalf. Not even the tribunal, members of the tribunal are required to be of qualifications held in a particular jurisdiction. And sometimes that is necessary because international parties who are engaged in disputes maybe parties who have nothing to do with Hong Kong, or maybe one of the parties could be a Chinese corporation. For example, recently I have an arbitration involving Russian parties and Chinese corporations. And the language that was adopted in the arbitration was English. And then we have a panel of arbitrators of diverse qualifications and origins. The lawyers who were handling the cases were Chinese lawyers with Russian lawyers backing up. So we have this diverse pool of talents that the parties can rely on in international arbitration. Whereas in court proceedings, the team of solicitors having conduct of the matter will always have to be lawyers qualified in the particular jurisdiction, and the advocates representing the parties will always have to be properly qualified in the Hong Kong jurisdiction, for example, and the same in any other jurisdiction indeed, except for advocates who are admitted on an ad hoc basis, on a case-by-case basis, to that particular jurisdiction. There is a myth of cliques of arbitrators. It is concerned, it has been sort of rumored to be a concern amongst the litigation professionals that, in international arbitration, there would be suspicions of unfairness because international firms tend to get the big cases, and then they would be friendly with the arbitrators they appoint or did not appoint, or even the chair who they did not directly appoint, and arbitrators would want to please these big firms in order to get repeat appointments. Speaking as an arbitrator who has regularly sat in cases for the past 7-8 years, I do not find that to have any truth in it. Although I have seen arbitrators who tend to be sort of ostensibly polite or sort of more obliging to particular firms. That could be for other reasons. That could be because that particular firm has already a good understanding of the culture in arbitration and understands the limits of behavior or adoption of practices. For example, in a particular type of application, they wouldn't make submissions which are off the line and therefore are received with more favor from the tribunal. So it does not necessarily mean that the tribunal would necessarily find in their favor just because a particular firm or a particular advocate is more reputable or famous or has more cases, as the case may be. There is this particular element that we should bear in mind, and that is, it is important for an international arbitrator to retain respect amongst his peers or her peers. And that element is a driving force to behave properly and to demonstrate fairness at all times. Next, what choices are offered, also on the point of what choices are offered in commercial arbitration that litigation does not offer? Well, we have consensual dispute resolution in international arbitrations. So parties have agreed in advance to resolve disputes in a particular manner, say arbitrations in Hong Kong IAC, under Hong Kong IAC rules. And they can also agree to the formats and the procedure that will be tailor-made to suit their needs of the particular dispute or the particular type of contract. The consensual nature of arbitration means that parties to commercial contracts will have put their minds to the nature of their agreements and how disputes are likely to arise. And parties, well, you can say that, well, but one party may have a stronger bargaining power. And for example, I hear that American companies in recent years, they do not necessarily want their disputes with any Chinese entities to be resolved in Hong Kong because they have suspicions or pretexts that Hong Kong may not be an independent jurisdiction anymore. Of course, there's absolutely no truth in that. And there is absolutely no evidence that is capable of supporting such a prejudice. However, parties will find themselves in their own bargaining positions and having different bargaining powers at the contract negotiation stage, and they can fight it out between themselves. There are also cascading dispute resolution clauses which make commercial arbitrations quite attractive, and that is the parties can agree in advance or in the middle of arbitration to go for mediation. And if mediation were not successful, they revert back to arbitration, subject to appropriate protection of the continued independence of the tribunal. The choice of arbitral institutions and which set of procedural rules to adopt, and rules of actual procedure within the arbitration, for example, document production and exchange, and the taking of evidence, and those are also attractive options that are available in international arbitration. Next point is that confidentiality is well protected, whether or not a court of law would objectively regard matters to be confidential and worth protection. In international arbitration, everything is confidential, and the parties are under mutual obligation not to disclose the nature of the dispute and any details within the arbitration. Looking to the future, we ask the question, is international arbitration developing towards the right direction, towards diversity or promoting better diversity? There are three aspects to it. The first I highlight is the mode of dispute resolution. Well, different rules are developed to suit the needs of different types of disputes. Rimsky has just highlighted some rules passed to help construction disputes towards a speedy resolution. And there are, of course, rules developed to deal with disputes on domain names efficiently and speedily. And these are all online procedures which seek to deal with smaller disputes more cheaply, more efficiently, without the actual attendance of the parties or their lawyers. I find that the most favored arbitral institutions tend to be progressive and responsive in updating their rules to suit the changing conditions and demands of the market. We are hoping to put together sports arbitration rules to set up a mechanism for sports disputes resolution. And we are also seeing an APEC ODR platform set up by EBRAM to resolve more cheaply disputes which are APEC in nature. Amendments to rules to quickly adopt to market environment is important to keep the arbitral scene alive and ahead of times. And arbitrators would be tasked to conduct the proceedings as cost efficiently as possible without compromising fairness, by including parties as much as possible in the design of the procedure most suited to the circumstances. The level of rigor of these rules would sometimes depend on how aggressive or cooperative the parties may be towards one another. And there is an increasingly strong tendency to ensure mediation is given a chance in the private dispute resolution process. Capacity building over the years have made available to the market mediation professionals, a strong body of them, of effective mediators seen to add value to the process. Right at the beginning of making mediation popular, we see that not a lot of professionals really know how to do it. So they were just sort of going through what they should go through generally, and they're not seen to add a lot of value. But after a few years down the line, we are seeing much more of a body of effective mediators to rely on. And that, in my view, adds significantly to access to justice. Diversity in format, I would quickly mention blockchain technology and ODR processes used currently in Hong Kong. The EBRAM APEC ODR platform is one of them. And we can see more of ODR, or online dispute resolution platforms, emerging in the future. Now, I wouldn't go back to the point, which is very often rehashed, of the popular nature of online hearings now. It is now prevalent in international arbitration. 3-4 years ago, I would still be hearing arguments from counsel saying that we must not have a video conference hearing because it is against the agreement of the parties, but now no longer. Quickly, I would mention diversity in arbitral panel. Why is it important? A 2021 survey shows that 37% of respondents thought it does not matter at all. 56% thought it matters a great deal, the diversity in the constitution of panel, and 36% thought that it matters. But where are we lacking in diversity? There are gender, racial, ethnic, geographical, cultural diversity, and diversity in training and background. Well, if we think about picking jurors, for example, it's not like picking jurors, because for commercial arbitration, there needs to be a certain degree of expertise. Otherwise, it's easy to get it wrong, in which case finality means that there's no way of overturning it, or very limited means of overturning it. So it is about a certain degree of expertise, and then on that basis, you try to build diversity. But it is not just about gender diversity. We have to understand what causes the lack of diversity and inclusiveness in the first place. And that could sometimes be the overvaluing of experienced or well-known arbitrators. And there is a deep sense of insecurity of choosing the wrong arbitrator and wanting to fall back on a safe choice. Next, there is asymmetry of information in the market on qualified arbitrators who are not well known. And there is a lack of transparency in awards informing professionals of the quality of a certain arbitrator. So all in all, I'm confident that in building capacity and making commercial arbitration more popular, there will be more information about arbitrators that would promote greater diversity amongst arbitration panel members. In 2021, Hong Kong IAC appointed 44 arbitrators, which was over 30% of all arbitrators appointed who were not appointed over the past 3 years. And that is a very commendable effort to make the arbitral panel more diverse. Now, who can make a difference? It is the parties, their in-house counsel, their counsel teams, arbitral institutions. And all of them will have to be aware of the positive qualities of a diverse arbitration panel. Diversity is fee structure. Rimsky has mentioned funding of commercial arbitrations and mediation. I would like to say a little about outcome-related fee structure. As Rimsky has pointed out, the recent amendment bill seeks to provide some more flexibility in free agreements between parties involved in dispute resolution outside the system of public administration of justice. There is already, this outcome-related fees is already permitted in a number of major jurisdictions. China has been very comfortable with it. Our China counterparts, mainland counterparts, they are very comfortable with outcome-related fees. They've always had it in their litigation, arbitration. And in fact, to not have such an arrangement possible in a jurisdiction like Hong Kong will, no doubt, hamper the development of Hong Kong as an international commercial arbitration center. In my view, it is market-driven need which is likely unstoppable, and Hong Kong should rise to the challenge, lest it is left behind. It is somewhat disappointing to learn that recently when the Law Reform Committee went to LegCo to try to explain the bill, it was not very well received amongst the legal sector of our LegCo representatives. It could be a result of a lack of familiarity or understanding of how it operates. But basically the argument was that we don't know how to play the game. We don't like it. That was basically the message. That is very, very disappointing because, well, legislators may owe their seats to people who elect them, but I think they owe it to Hong Kong to let us progress and develop as an international arbitration center. And I think the ORFS will be significant in that regard. So thank you very much.
I'm sure you'll join me to thank Winnie for the excellent presentation. All the topical issues that a lot of our participants have in mind have in fact been covered in Winnie's presentation. So we can tick off a few of the questions that have been submitted after your presentation. But given the limited time we have, without further ado, a number of questions have been submitted either online or by participants. So I will proceed to the Q&A session. And our panelists will forgive me for diving straight into some of the topics that a lot of our participants have in mind, because there's actually quite a bit of overlap in the questions that have been asked. Can I start off with this? It is one of the questions asked is promotion of the rule of law amongst the general public is one of the important initiatives of the government. Now, as arbitration proceedings are conducted in private, details as to how arbitration is conducted and the results are generally not available to the public. In your view, how should the arbitration industry participant attempt to promote the rule of law to the general public by participating in arbitration? Now, the chairman of the HKIAC will forgive me for directing this at you first, but I'm sure you have been asked this question in the past. Rimsky.
Victor, thank you for the question. I think it's a very good question. Actually, it's been asked in this manner as well as in slightly different manner. Perhaps to begin with, confidentiality is of course one of the cornerstones of arbitration, but it doesn't mean that information about arbitration is totally lacking in the community. In some jurisdictions, some arbitral institutions publish digests of arbitral awards, just like cases. Of course, you won't find the names of the parties, you won't find the details which enable you to second guess who are the parties in the disputes, but these are one way to deal with the situation. And since you asked me in my capacity as a co-chair, allow me to do this commercial. Actually, last year, the HKIAC put forward a new platform called the HKIAC Case Digest. It set out the past decisions by the HKIAC on decisions relating to the implementations of the rule as a summary, so that you know how the rules are being implemented. And in fact, we got the World Arbitration Award for rolling out this HKIAC Case Digest. These are perhaps the more technical or logistical solutions. But another way of looking at the matter would be, I think it's for the arbitral community, particularly the practitioners, to go out and explain what exactly arbitration is. Because in some instance, in some jurisdictions, in some sector, this issue has been raised and quite seriously, if I may. And that is, they see a sense of secrecy behind arbitration, when in fact it is not. So I think the arbitration community has a duty to explain more to the outside world, not just the in-house counsel of big enterprise, but to the community generally, the rationale behind arbitration, as well as the benefits that can be brought about by both domestic and international arbitration. Thank you, Victor.
Yeah, thank you very much, Rimsky. Now, the questions keep firing in. I will continue. I've been asked to direct this at Robert. How do you think online dispute resolution may change the ecology of dispute resolution mechanism? I mean, do you envisage that face-to-face arbitration, mediation, or even litigation may gradually be replaced by online means? I mean, we all know the HAIC has done a great job in moving disputes online. We have all done hybrid or hearings that are fully just on the internet. But what is the recent trend and what is your experience? And what do you think is going to happen?
Online hearings are, of course, very convenient. But I'm not convinced that it is going to replace face-to-face hearing, which has other advantages. For example, if you have a panel of arbitrators, they will be together. And when you are in the room with counsel for both parties and the parties, I think it's much easier for there to be interaction between them. Internet hearings are useful because often you have witnesses who are scattered around the world, and because of COVID, travel has not been easy. And of course, there are, even without COVID, there are witnesses who are not vital to the resolution of the dispute, but who are nevertheless important witnesses. And it could cut away time and expense if they don't have to go to the place where the arbitration is held physically. But on the whole, I believe face-to-face physical hearing is likely to continue, especially in the more substantial arbitrations.
Thank you very much. Now, and of course, over to Winnie now on the topic of diversity in arbitration panel. Now, the participant said that there's a tendency to nominate well-known arbitrators rather than spending time to make inquiries about someone that you have never worked with. Now, in your view, how can the Arbitration Institute assist lay client to pick the right arbitrator? What can be done? Do you think we can set up some sort of KPI for arbitrators, have more information on the objective information on how good or how bad they are? Any views on this?
I think arbitral institution play an important role in that, for example, in appointing a sole arbitrator or the president of the tribunal, the work of the appointments committee would involve shortlisting suitable candidates. And that, of course, will have to be a list, suitable in the sense of legal qualification, amount of experience, commensurate with the size and nature of the case. And sometimes you also have to look towards what sort of co-arbitrators have been appointed. Now, in that regard, for example, if the parties have appointed very experienced arbitrators as co-arbitrators, then the arbitral institutions will find itself constrained to appoint a chair of commensurate experience, lest the chair would be lacking in authority. Now, if the parties would be prepared to research into suitably qualified arbitrators who are prepared to work hard, prove themselves, and at the same time will have the guidance of the chair, then that would be a different game. So as I see it, all the council teams, the parties, and arbitral institutions all have to work together in order to ensure a thriving and ever increasing number of arbitrators in the pool in order to facilitate administration of justice in the international arbitration context.
Thank you very much, Winnie. Now, a question just came in about mediation, and I will direct this at Rimsky. The chief executive has announced to further promote the culture of mediation in the policy address. What is your view on how to encourage participation of mediation in different sectors, and which sector may benefit the most from utilizing mediation?
Thank you, Victor. I think mediation, if you look around the different jurisdictions in the world, whether common law jurisdictions or civil law jurisdictions, mediation has been used in many different sectors and different areas. In Hong Kong, I think so far the use of mediation has been primarily in civil disputes. For instance, matrimonials and say small claims disputes. But I think there is room in Hong Kong to further enhance the use of different types of mediation. What we need is the mediation community should go out and promote mediation. At the same time, I think facilitation by the government would also assist, such as providing more course, more training to people who would be qualified in the different areas of mediations. For instance, I can give you one example. In some other jurisdictions, there are mediators in the schools, in the high schools, and the schemes turn out to be extremely successful, not only allowing seniors in the school to mediate disputes among the juniors, but it actually helps to promote the upbringing of the kids in the school. And another example I can give in terms of variety is that in Hong Kong or in many common law jurisdictions, mediation is not used in criminal related matters. But in some jurisdiction, in the less serious crime, mediation also has a role to play. So sky is the limit. It depends on how much resources we can get to further explore the use of mediation in the many different areas that we can have in the community. Thank you.
Thank you very much. Now, I won't be able to finish all the questions, but let me pick a couple that is more interesting and less discussed. Now, Robert, I'm sure you have heard arbitrations where the governing law is not Hong Kong law, English law, and you have lawyers making submission in front of you that are not qualified to practice in that particular jurisdiction. So you have English lawyer making submissions on continental European law, PRC lawyers making submissions on English laws. We have experience of that. Contrast how we do it in court. Foreign law is a matter of fact, of course. I think you've written a judgment on that. Which model do you prefer, and what is your experience in that regard?
Well, very often, if a matter of foreign law is involved, there will be expert evidence on foreign law. But when it comes to commercial law, I'm not sure that there is really that much difference between Hong Kong law and, say, Chinese law. The details may be different, but the thinking behind it is the same. And the approach to the legal problem is the same. So it's never been a problem so far as I can see it.
And Winnie, do you have some experience as advocate? I'm sure you have argued cases. I know you have at least argued cases based on PRC law, so you can share some of your insights on.
Yes, we do, and we always do it with lots of help. So even if an advocate is only an advocate conducting the advocacy is not qualified in the law of that jurisdiction, it doesn't mean that he does not have help in supporting his submissions. So I have frequently drafted all the sort of Hong Kong law submissions for another team of counsel from America or somewhere else, for him or her to advance without me appearing in the arbitration. So it would be in their interest to have lots of help. So it doesn't mean that they would advance submissions that are necessarily incorrect. And in any way, all the submissions are well reasoned and backed with authorities, which the arbitral tribunal can duly assess. And often, if it is a case involving foreign law, there would often be at least one member of the tribunal who is familiar with the law of that jurisdiction. So in that sense, it also helps ensure that the arbitral tribunal gets it right.
Thank you very much. Now, we're running out of time. Finally, I have a question from a young lawyer who wants to go into arbitration. He said he's finding it difficult breaking into the market. He's not well known. Where are the opportunities? So I think all three of you, please chip in, because the person who asked the question sounds pretty desperate.
Wait, may I go first? Because I've often had to give this advice. So, well, I work very hard on the appointments committee to try to draw attention to younger qualified arbitrators. But I think the younger candidates have to help themselves as well. I think, first of all, you have to get the right qualifications, get the memberships of the institutions like the Chartered Arbitrators, Chartered Institute of Arbitrators, etc. And then you have to be seen in the circle, in the sense that you have to let people get to know you better as somebody who, say, have the opportunity to speak on a topic. And that you can do via whoever you practice with, either in a firm or in barristers' chambers. It is better for someone to have heard you or to have noticed your existence, for a start, to know your expertise, to know that you know a certain area of the law, and that would add to the attention paid on this person as a potential candidate. The arbitral institutions are, well, at least the HKIC is very good at it, always looking for potential candidates to appoint. And of course, once you break into the market, so to speak, for the first time, gradually there will be more cases. And the low-value cases are absolutely perfect for trying out new arbitrators. So it is not entirely hopeless, but you have to work very hard on it and not over-represent your own ability and experience.
Thank you. I think the young person also want to hear from Robert specifically, because in giving advice to young people, they're looking at the most senior practitioners here.
Well, I think if one is really interested in arbitration, one may wish to begin by acting as secretaries to arbitral tribunals. I think that is normally the best start. Otherwise, as a young lawyer, one should not expect to be appointed as an arbitrator too early in one's career, because you can look at the appointment of judges, say appointment of district court judges. There's a certain minimum years of practice before one becomes qualified. But the fact that the qualification may be set at 5 years or 7 years doesn't mean that a person who's done 5 or 7 years would be appointed. It takes time, because being an arbitrator is I think carries with it a very heavy responsibility. So I would suggest that they start by becoming secretaries to a tribunal. In order to do that, they have to, of course, make known their interest. And I think the best way to do it is to come to know some busy arbitrators, and hopefully they will become noticed and then eventually appointed.
Thank you very much. I believe our time is up. So on behalf of the panel, can I thank the Department of Justice again for organizing this conference and putting this panel together. And I'm sure all of you will join me in thanking our three distinguished speakers.
Thank you. definitely also a big round of applause to our fantastic moderator, Mr. Dawes. Thank you so much. So now I would like to invite our moderator and our three distinguished speakers. Please remain seated and look at our official photographer right in front of you to capture this important moment. What an inspiring and also wonderful section we had just now. Once again, ladies and gentlemen, a big round of applause to Mr. Dawes, Justice Tang, Mr. Yun, and Ms. Tam. Thank you so much. Please be seated. Here wraps up our second panel section of today. And before we proceed to the third panel section, we will have a 15 minutes break. So please enjoy the refreshments in room N204 to N210, which is opposite to this conference room. And also remember to return to this hall before the start of the third panel section. The starting time of our third panel section will be 3:45. So enjoy the refreshments, and for our online participants, please remember you don't need to log out from the system. So see you all in 50 minutes. Have a wonderful refreshment. Thank you. Ladies, gentlemen, good afternoon. We shall resume our third panel section shortly, so please kindly make your way back to the conference hall. Thank you. 咁多位嘉賓，我哋咧即將開始我哋第3場嘅專題研討環節啦。咁所以咧，我哋有請喺會場外嘅嘉賓啊，立即咧移步翻嚟到會場入面嘅位置啦，同我哋參與最後一場嘅專題研討。多謝咁多位。Ladies and gentlemen, good afternoon. We will resume the third panel section now, so please kindly make your way back to the conference hall as we would like to start the panel section as soon as possible. Thank you. 咁多位嘉賓，我哋第3場嘅專題研討咧，立即就會開始啦。想喺呢個時候咧，邀請喺會場外嘅嘉賓啊，立即移步翻嚟到我哋會場入面嘅位置，咁等我哋啦可以立即開始我哋嘅專題研討環節。唔該晒大家。Hello， 咁多位嘉賓，大家下午好。喺呢個時候咧，我哋即將開始我哋今日最後一場嘅專題研討啦。咁今日咧就好高興啦，嚟到咧我哋香港法律週2022法治大會法治公義普惠共存嘅最後一場嘅專題研討啦。而呢一場研討啦，其實記得啦，剛才喺今朝嘅開幕儀式入面啦，司長都提及到係一個非常特別嘅一個研討會嚟嘅。因為今日咧，我哋除咗啦邀請咗一啲資深嘅學者啦、專家啦，同我哋探討唔同議題之外啦，接住落嚟呢一個專題研討啦，我哋邀請咗一班年輕嘅一代啦，同我哋啦探討一下，同埋分享下佢哋嘅觀點嘅。今日我哋最後一場嘅專題研討名為《社區對法治的承諾：年輕一代的角色》。咁我哋好高興啦，邀請到以下嘅嘉賓嘅，咁分別有 Sharon 譚雪欣小姐做我哋嘅主持人，俾啲掌聲歡迎 Sharon 先。當然唔少得啦，亦都有我哋一眾嘅分享嘉賓，分別有 Kelvin 鄭偉邦先生，有 Angel 黃海蓉小姐 ，Glenda Tan 同學，當然唔少得，亦都有 Lim Shan Shin 同學 ，Jason 張博濤先生，以及 黎曉道先生作為我哋嘅分享嘉賓嘅，歡迎晒咁多位，歡迎你哋。好啦，將個時間咧交俾我哋嘅主持人 Sharon 之前啦，再一次咧提提我哋現場同埋線上咁多位嘅參加者。咁喺我哋咧呢一個專題研討之後啦，將會有一個答問環節㗎。如果你哋有任何問題啦，都歡迎你哋將你哋嘅問題寫低，然後交俾我哋嘅工作人員，又或者啦可以好簡單咧掃描一下我哋一陣間會顯示嘅二維碼，將你哋嘅問題咧輸入去到我哋嘅答問系統入面都得㗎啦。咁當然啦，線上嘅與會者啦，你哋更加可以直接將你哋嘅問題輸入去到我哋嘅聊天室入面就得㗎啦。咁我哋嘅嘉賓啊，將會喺最後嘅一啲答問環節入面啊，去回答翻大家嘅問題㗎。好啦，事不宜遲啦，我見到咧主持人 Sharon 都望住我啦，都急不及待啦，想同年輕嘅一代咧多啲交談。事不宜遲，將個時間交俾 Sharon。
Good afternoon, distinguished guests, ladies and gentlemen. Welcome to the last session of the Rule of Law Congress today, and also the very final session of the Legal Week, which is organized by the Department of Justice. I'm very honored to be invited to be the moderator of this session, and to give a bit of my background, I'm actually a Hong Kong practicing solicitor with an international law firm and also the vice president of Y Legalites, which is a young lawyers platform dedicated to the rule of law promotion to the young people as well as the general public. I would like to rewind a bit to last week when I was preparing this session together with all the young speakers. I was actually repeatedly told that this session has received a lot of attention from many people, including, of course, the organizing team of the DOJ and also the Secretary for Justice, as he has remarked this morning in his opening speech. And actually, needless to ask why, I think it is fair enough that nowadays it is very important and we are always very keen to listen to the voice of the young people nowadays. And by looking at the topic that we are going to discuss today, we actually see three key elements. And first of all is the rule of law. And this is something, well, to many sounds like very grand and not very easy to understand. But at the same time, someone may find that it is quite simple, and at the same time, it is quite complicated. When I say it is quite simple, it is because many of us actually know that the rule of law is actually the cornerstone of Hong Kong's success. And I have also heard from many youngsters saying that當佢哋睇電視劇嘅時候，好多時候啲對話咧，如果兩邊有嗌交咧，都會講到話香港係一個講法治嘅地方嚟嘅喎咁。And that's why, actually, I think at the community level, the term 法治 is actually known and very familiar to many of us. And of course, at the same time, there are also a lot of core elements that are always here in the concept of the rule of law in Hong Kong, such as everyone is equal before the law, independent judiciary, as well as everyone must obey the law. But I'm not going to elaborate further here, and I will defer this discussion to all the young and talented speakers later on. And by looking at the topic, we have the second and the third element. The second element is community, 社區, together with the third element, that is the young generation. And actually, I do think that when these three key elements putting together, they make a perfect match. It is because although young people being young, it may not be an advantage in terms of maturity and experience, but actually in Cantonese, 年輕新一代, when we talk about 輕, it actually means light in English. So young people, we do not have any baggage, we don't have any burden, and so we can be more straightforward in sharing what we have been thinking. And also, young people is very good at learning, unlearning, and relearning. So we always pick up things very quickly. And young people, they are very innovative, creative, and indeed, they are very close to the recent trend and the development of the society. And all these good qualities actually are very conducive to the promotion of the rule of law in the modern world and to the community. So probably young people, they are actually in quite a good position to give suggestions and recommendations on how to bring proper understanding of the rule of law into the community. And we can also give some good suggestions on how to do it in a more effective way as the concept of rule of law evolves with the development of the society. And we always need to accommodate new elements in the rule of law promotion and education. Given this session is really the finale of the legal week, and we have a lot of bright and young minds getting together here, we really hope that this session can be more relaxing, just like 後生仔傾下偈. And in fact, just like similar to what Hong Kong is, we have people with diverse background here, and so it will be conducted quite differently from all the previous session, and we would like to have all the speakers free to choose their own language in sharing what the rule of law means to them. 所以咧，今日咧，其實我哋呢一個嘅專題研討會咧，都希望係可以用3語嚟進行嘅。今日咧，我哋嘅講者咧，其實佢哋都會用唔同嘅語言，包括廣東話啦、普通話啦同埋英語咧，去同大家咧討論一下究竟法治係點樣可以融入同埋進入個社區嘅。So now, I would like to take this opportunity to introduce all the speakers to you. And today we have Kelvin here. Kelvin is actually a good friend of mine, and we have been working in the Law Societies together for many years. He is a council member and the chairman of the Young Solicitors Group of the Law Society of Hong Kong, and now he is a partner of Yong Yu Yun and Co. And also we have Angel here. Angel is a practicing barrister and also the vice chairman of the Young Barristers Committee of the Hong Kong Bar Association. And today we have Li Xiaodao. Li Xiaodao is actually a PhD candidate of the University of Hong Kong, and he's going to share with us how they view the rule of law in Hong Kong from a Hong Kong drifter's perspective. And today we are very honored to have Glenda and also Xin Shan, and they are actually have just arrived in Hong Kong like 2 days ago, and thank you for flying over in order to join this conference. Glenda is a law student with the National University of Singapore, and she is also the best presenter in the International Youth Legal Exchange Conference in 2021, while Xin Shan is the chairman of the University of Malaya Young Leaders Association and has earned the Best Paper Award in the International Youth Legal Exchange Conference in 2021. And last but not least, we have Jason here. Jason is actually the young local entrepreneur, and he has his own startup specializing in education technology. So without further ado, may I now invite Kelvin to be the first in sharing? Kelvin, it's over to you, and thank you, everyone.
Thank you, Sharon, for your introduction. Secretary for Justice, distinguished guests, fellow panelists, ladies and gentlemen. I'm very delighted that DOJ has offered me an opportunity to share with you my views on the rule of law, and also to share some of our experiences in the Law Society of what we have done for the community in involving the community on educating them on the rule of law. When I was invited to speak on this topic, the first question obviously came to my mind was, what is the rule of law? And the first thing that came to the top of my head was, well, everyone is equal before the law. And the obvious principles that come from it is that the law applies to everyone. The laws are not arbitrary. The laws are enforced fairly, and the judiciary is fair. And given that guideline, in my feel and thoughts, I believe that an independent judiciary is the key and cornerstone to whether we have a strong rule of law. And that is the reason why, as a lawyer in Hong Kong, I have a very strong conviction that the rule of law in Hong Kong is very strong. However, that is not what I see in media, especially in international media, where we have come across comments where they talk about Hong Kong's rule of law eroding. And that brought me to the next thing that came into my mind was, is it because my understanding of the rule of law is different than anyone else? And so I started speaking to people within my profession and also outside my profession and asking them, what is their feel and thought of the rule of law? And the answer came out quite unsurprisingly, actually, and it is that everyone had a different interpretation, different meaning of the rule of law. And so, to me, everyone's way of saying rule of law is different, and there is nothing universal about what really the general public's feel of what the rule of law is. Given the arbitrariness, out of a lack of a word for it, of the term, I then turned to the online sources to see what the rule of law could be. And when I obtained from sources of what the rule of law could be, I came up with ideas of security, freedom, rights, all of which are concepts that differ from my belief of what the rule of law is. I mean, they are good points to consider for the community as a whole, but they are rather remote to when we speak about the rule of law. So this leads me to consider my first point, which I want to share with everyone today, and that is, how can one judge another's rule of law? If a term like the rule of law is so arbitrary and not universal, then how can the rule of law of a particular jurisdiction be assessed? What elements are used in judging the rule of law? When the judges are assessing the rule of law, what are they basing it on? Can there be a perfect rule of law? And this leads me to the very, very obvious question. Can the rule of law exist not just in a democratic society, but also in a non-democratic society? Can the rule of law exist not just in a common law jurisdiction, but also civil law jurisdiction? Obviously, I'm not here to discuss further on this, but what I want to spark is just an idea, a question, a wonder, whether we can truly and justifiably assess someone else's jurisdiction's rule of law. And in my belief, I believe that there can be rule of law for both non-democratic societies as well as civil law jurisdictions. And I believe that only the citizens that are living in that community can judge and assess their own rule of law. Now, under my interpretation of the rule of law, obviously it goes without saying that it is very, to some people, a narrow interpretation of what it means. And I find that there are people that are looking into what good laws and bad laws are, and that actually puts an impact on how they feel the rule of law of a jurisdiction is. But to me, they are two separate concepts. And so, in my opinion, I want to also raise this out, is whether these two concepts should be mixed together or whether they should be separate concepts to be considered. And so to me, when it comes to educating the public on the rule of law, I think the critical thing that we need to impress upon the public is how our legal system works. Because the more educated, informed people are about our legal system, the more they can actually get themselves to know whether they can separate the concepts between the rule of law and the political way of affecting what the rule of law is. And here, I would like to share what the Law Society has done in respect of community involvement. In the Law Society, we have had a flagship event called the Teen Talk, where we involve the community, especially the high school students, in dealing with particular legal topics every year and helping them in involving and getting them to understand the various legal topics that we have in Hong Kong. So you can see on the slides that there are all the themes that we've had all over the past years, all are very interesting topics. Over the 10 years, we have actually had more than 15,000 students in the aggregate involved in this. And I believe that this is for a greater cause of the public, and so we must continue on with it. And this event has grown bigger and bigger over the time. You will see in the photos that we also have distinguished guests come in to actually share their views every year. And it is very fortunate for us to be able to arrange that. You will see there's also opportunities for students to go to legislative building to actually have mock debates on legislative bills. Previously, we also have trials at high courts to have mock trials as well. And so these are experiences that I believe that the Law Society has afforded to the students over the years to help them gain an understanding of our legal system and the rule of law. For the last year of the Teen Talk, we actually had a flagship event of having to arrange the visit of the various disciplinary forces. And so students were able to go to these disciplinary forces where areas that are typically not open to the public. And they got to experience the various things and actually have them see them in action, having a fire and having to be able to take out the fire. And so this is something that we will continue on, and I believe that we will stay strong on this and continue to help the public on this. The next initiative that I want to mention is actually something that is for a brainstorming purpose. And this is something that under the Young Solicitors Group, we have done so for the past 2 years. And this is something more of a treasure hunt game, but hopefully using a game version to help people break the ice, know their own members more, in particular between the young practitioners and the senior practitioners. And you will see in the slide that they take pictures. What happens is there's a riddle, and they solve the riddle amongst the group. Once the riddle is solved, they will know where to go, and they will take photos. And then once that photo is taken, it goes to the game master, and throughout several weeks, they will then end up having a winner who has won it best in terms of the event itself. So this is something that we have implemented so far in the past 2 years, and I hope that this can actually be implemented in the community-wide, such that we can perhaps have groups with various ages, various industries put together so that people can actually hear different perspectives, and they can be exposed to things that they normally wouldn't be exposed to if it is not for the event. And that sums up pretty much what I want to present today. Thank you very much, DOJ, once again, for allowing me to share my views today. Thank you.
Thank you very much, Calvin, and thank you for introducing us Teen Talk as well as the scavenger hunt that was organized by the Law Society of Hong Kong in promoting the rule of law, not just among the young generation, but also among the young lawyers. And just to mention in passing, I recall the group that I belong to actually was the champion in the scavenger hunt last year. So yeah, I was very happy about this. 好，咁我哋而家咧就有請阿 Angel 去分享一下我哋香港大律師公會咧有啲乜嘢嘅 initiative 去推廣法治嘅。有請 Angel。
律政司司長、各位來賓、先生、女士。首先呢，我謹代表新晉大律師常委會呢，好多謝律政司舉辦呢一個香港法律週嘅活動啦， 並且咧係邀請我哋去參與呢個活動，同大家分享我哋委員會做嘅事情。咁亦都好榮幸咧，作為呢個常委會嘅副主席咧，今日係有機會咧去同大家做呢個 presentation， 以及咧係同其他嘅 speakers 咧陣間可以就住法治呢個概念咧進行唔同嘅討論嘅。咁事不宜遲啦，或者先簡介下，咁到底其實我哋呢個常委會係乜嘢嚟嘅咧？係。咁我哋新晉大律師常委會 Standing Committee on Young Barristers， 其實我哋有另一個更加為人熟知嘅名啦，就係 Young Barristers Committee。咁所以咧，我哋平時都係叫自己做 YBC。咁陣間落我都會同大家講YBC 做咗啲乜嘢咁樣。咁我哋咧其實就係每一年咧都會有大概20至25個成員啦。咁都會係YBs 嚟嘅 Young Barristers， 即係新晉大律師。咁新晉大律師嘅意思咧，其實就係話係7年，即係 admit 咗係啦，成為執業之後7年內嘅咧，咁都係新晉大律師嘅一部分嚟嘅。咁我哋嘅成立嘅宗旨啦，咁我哋希望咧可以俾新晉大律師互相之間係有一個交流啦，亦都咧我哋會代表新晉大律師去推廣佢哋嘅福利等等啦，同埋咧，我哋希望新晉大律師咧，同埋行內嘅前輩咧，係能夠有一個交流嘅。咁但係當然就唔止係咁樣啦，因為咧其實身為法律界嘅一份子咧，其實我哋都知道咧，法治教育係非常之重要嘅，而且咧仲有2個重點。第一咧就係需要普及。點解咁需要普及呢？嗱，好多時候咧，我哋自己係受咗法律嘅訓練啦。其實我哋都會忽略咗對於普羅大眾嚟講咧，呢個制度對於佢嚟講本身可能係好陌生。咁所以可能咧，在場有唔少嘅人士，佢哋譬如去做當值律師啊，或者去做免費法律諮詢嘅時候咧，接觸到唔同階層嘅人士咧，就會更加感受到呢一樣嘢，就係可能咧，佢連上庭嘅時候嘅基本程序係乜嘢，佢都唔知啦。或者佢自己其實法庭點解係咁做啊？入到去其實有啲咩禮儀要遵守啊？或者自己有啲咩權利咧？佢唔知道，於是當然亦都談唔上可以討論進一步嘅事情啦。即係一啲更加抽象嘅概念，其實佢都未必可以討論到。調翻轉頭咧，一諗到要面對法律嘅程序咧，可能都係會覺得害怕等等。咁所以第一樣嘢，其實我哋都好希望法律唔係一件離地嘅事情，而係大家無論係乜嘢階層嘅人，至少都知道其實香港嘅司法制度係點樣運作嘅咧，自己又有啲乜嘢權利咧，咁先至可以做到下一步嘅討論啦。咁第二樣嘢咧，就係呢個法治嘅教育都要及早做啦。咁因為其實我哋都希望藉由喺年輕人佢哋讀緊書嘅時候已經有機會可以用佢哋嘅課時或者課外活動嘅時間都好，可以接觸到相關嘅概念。咁而且咧，如果有一啲年輕人佢哋接觸咗之後發現其實 law 呢樣嘢都真係好好喎，咁話唔定咧都可以為到我哋香港法律嘅專業咧吸納到更加多嘅人才。咁所以跟住落嚟咧，都會同大家分享下我哋 YBC 咧，咁有唔同嘅委員附屬委員會啦。咁其中咧有2個委員會咧就有做到相關嘅活動嘅。咁第一樣嘢咧就係叫 Street Law Programs。咁乜嘢叫做 Street Law 咧？其實 Street Law 咧係一個新興嘅法律教育嘅項目啦。咁強調嘅咧就係用一個創新同埋互動嘅方式咧，去令到普羅大眾咧係會更加對法律知識咧係有個渴求嘅，即係唔單止係認識，係希望令到佢哋更加想知道到底乜嘢係法律啊，或者乜嘢係法治等等。咁我哋咧呢一個Outreach 外展嘅附屬委員會咧，咁其實有同一間叫做 Street Law Hong Kong 嘅機構去合作。咁 Street Law Hong Kong 亦都係香港一間新嘅企業咧，就係希望去推廣法治教育與普羅大眾嘅。咁所以譬如喺舊年年底嗰度啦，咁雙方合作咧就喺新界區嘅一間中學咧，係為全級嘅同學舉行咗一個工作坊嘅。咁我哋就會問咁個工作坊到底係做啲乜嘢啊？係咪就係同佢哋講座？都唔係嘅。咁我留意到頭先 Kelvin 嘅 presentation 都有講到有啲遊戲啦。咁我哋呢度都係有一啲遊戲係同大家有一齊玩嘅。咁聽落好得意嘅，就叫做呢個登陸火星任務。咁聽完大家都諗 即係點咧？即係突然間登陸火星。其實咧，我哋就係假設緊咧，如果而家我哋有需要去火星，咁我哋喺地球嗰度咧，唔同嘅區域咧就要搜集物資啦。咁搜集物資嘅時候就梗係時間緊迫啦，因為你要去第二個星球啊嘛。咁我哋就將同學分組，然後每一組咧佢哋就要去即係比賽係要去攞啲唔同嘅物資翻嚟嘅。咁但係咧，攞物資嘅時候咧，佢哋就需要為唔同嘅組別去設立規則，即係話咧，可能有一組咧就話下一組咧就要少10秒㗎啦，或者咧下一組咧就唔可以用手嚟去執嘢嘅，可能要用其他方法等等嘅。咁訂立咗呢啲規則之後咧，就其他同學仔就要遵守啦。但係喺你舉出呢啲規則之前咧，你就未必知道自己會唔會係呢啲規則嘅所謂嘅要遵守呢啲規則嘅人。咁點解要進行呢啲嘅遊戲咧？其實都係想話俾大家聽到底規則嘅作用係乜嘢，或者規則係點嚟嘅咧？或者係對於佢哋嚟講喺咩情況之下，佢哋覺得乜嘢嘅權利係最重要等等咧？我哋都會喺呢啲機會咧同佢滲入一啲法律嘅法治嘅概念嘅。咁而喺結束咗呢個任務之後咧，亦都有一個帶住同學仔去前粉嶺裁判法院嘅一個探訪啦。咁然後我哋 YBC 嘅成員咧就會成為咗呢個導遊，咁就一路同佢哋行呢個裁判法院，亦都會同佢哋講翻其實裁判法院裏邊嘅法律程序係咁嘅喎。咁等大家咧有翻一個正確嘅認知，因為咧有時即係大家都會好似頭先咁講，睇到電視劇 Sharon 都有提過啦。大家都會講香港係一個法治嘅社會，但係有時電視劇嗰啲法庭戲咧就有稍嫌少少誇張咗啲，咁所以喺呢啲時候咧，我哋都會同翻同學仔講其實實際上咧，我哋嘅執業嘅過程咧就係咁樣嘅。咁好啦，除咗呢一個活動之外啦，我哋亦都有參與到 Street Law Hong Kong 嘅模擬法庭暑期學校去協助咧解釋一啲相關嘅基本概念。咁我哋預期咧未來仍然都係會有繼續呢啲 Street Law Programs 嘅。咁除咗認識之外咧，其實我哋都相信咧，我哋要俾一啲機會同學仔啦，佢哋係有個平台可以討論同法律相關嘅議題嘅。咁所以咧，跟住落嚟就同大家簡介下我哋每一年嘅活動，就係香港大律師公會嘅辯論比賽。咁其實咧，我哋都搞咗呢個活動好多年㗎啦。咁亦都咧，我哋嘅特色就係咧，唔單止個辯題係同法律相關啦，咁亦都我哋會邀請大律師以至係咧法官咧去擔任比賽嘅評判，咁好讓咧同學仔可以唔單止可以聽到從法律專業角度嘅評語，亦都咧完結咗之後咧可以同行內嘅人士去交流，咁獲益良多。咁所以亦都唔單止俾咗機會佢哋去發表自己嘅意見，亦都係啦，進一步俾咗溝通嘅機會大家。咁所以以上呢啲活動咧，就係一啲例子去講YBC 點樣去做法治嘅教育啦。咁未來咧，我哋都會向住呢個方向咧繼續努力嘅。多謝各位。
唔該晒 Angel。多謝 Angel 同我哋分享一下，即係香港大律師公會其實佢哋對於推廣法治係點樣做啦。咁頭先亦都有講到啦，就係我哋平時咧喺電視劇集係真係成日都聽到可能講一啲法律或者一啲法治嘅概念喎。咁可能有陣時咧未必係絕對正確嘅咁所以咧我哋亦都好依賴住我哋而家我哋有嘅兩個 professional body 咧，去將法治有一個正確嘅演繹同埋正確嘅理解，然之後咧將一啲咁樣嘅知識咧就可以傳俾我哋嘅新一代啦。好咁而家咧，我們下一位講者就是李小道。小道是香港大學的博士候選人，今天他會跟我們說一下有關於在香港的內地學生對法治的理解，還有就是內地學生是怎樣可以更好推廣法治的一些看法。有請。
尊敬的各位来宾，大家下午好！很荣幸有机会参与法治大会并在此发言。我今天要演讲的题目是法律信仰的必要与建构，它副标题是关于内地学生与香港法治的几点思考。在内容上，它可以简单的分为3个方面，我想简要的谈谈一下3个小的问题。第一， 为何内地学生应当关心香港法治？第二，内地学生为何需要建构对香港法律的信仰？第三，内地学生如何去建构对香港法治的信仰？首先，我们来看第一个问题。最简单的一个回答就是，香港法治它对于内地学生自身的利益具有重要的影响。在此的话，我想引用一下建构主义的视角。根据这个理论的话，构成性规则它可以塑造一个社会成员他自身的观念以及身份。这样子的表述可能有点抽象，我就引用一下一个比较通俗的例子。相信在座的各位都可能接触过麻将，或者听说过麻将，甚至打过麻将。然后，如果没有麻将的规则的话，麻将这个游戏是不会存在的。麻将的规则它本身规定了玩家的身份以及玩家的玩法。没有规则的话，玩家们并不知道谁是上家、下家、对家，他也不知道胡牌才是最终的赢得游戏的方法。所以我们可以看到，规则本身它可以建构成员自己的利益，还有他们的身份。类似的，对于内地学生而言的话，他们的身份和利益都受到香港法律的深切的影响。比如说，《基本法》第3章它就规定了香港居民的基本权利以及基本义务。然后我们可以看到，作为非永久性居民的内地学生，他们的身份以及他们的利益都是受到法律的重要的影响的。自然，他们也需要关注影响到他们的香港法律以及在此基础上所建构起来的香港法治。那么我们可以肯定，内地学生他需要关注香港法治。那下一个问题就是，为什么内地学生他要建构起对于香港法律的这样子的一种信仰呢？在此，我觉得第一点很重要一点就是，法律信仰它本身就是法律规则本身的重要的力量的来源。在此，我想再次引用一下麻将这个例子，因为我们看到在打麻将的时候，玩家们之间的游戏是不需要警察来维持秩序的。然后打完麻将之后的话，他们也不需要一个法庭跟法官来宣判谁输谁赢，他们不需要法官来说你詐糊喎，你唔算贏，你係大相公，你係小相公，你贏唔到。不需要，因为麻将它本身的规则已经被玩家所深深的认可、接受和理解了，所以它规则本身如果被接受和认可的话，它的生效就不再依赖于强制力来保证实施。这也是为什么著名的学者伯尔曼会说出那句“法律必须被信仰，否则它将形同虚设”。然后第二点就是，香港它的法治的话，它会受到内地学生的法律信仰的重要影响，因为内地学生他们的法律信仰的话，可以支持他们去积极参与香港法治这样子的一种实践活动。在此，我想引用一下吉登式的结构化理论。根据这个视角的话，所谓的制度其实是在较长的时空程度内、尺度范围内所形成的一系列稳定的社会实践。而从这个视角来说，香港法治它不是一种写在法条上的文字，也不是打印在传单或者口号上面的话语，它是一种在香港社会内所形成的一系列的超越时空范围的稳定的符合法律的一种社会实践活动。因此，作为社会成员中的重要组成部分的内地学生，他们的观念、他们的思想以及他们的实践，对于香港的法治具有重要影响。而且很重要的一点就是在于，香港学生不是内地学生，不好意思，他们的特殊身份上具有时间和空间两个方面的特殊性。在时间方面的话，相当部分的他的内地学生，他可能会成为永久性居民，然后在香港的社会中持续的活动，然后他们的观念还有他们的实践，对于香港法治具有着持续性的影响。然后这是时间方面的特殊影响。然后在空间方面的话，内地学生他在内地以及香港两方面都有自己的圈子，因此他可以在香港法治实践的过程中发挥重要的作用，可以对内地以及香港两个群体、两个区域施加特殊的影响力。如果内地学生能够发挥重要作用的话，它将大大的能够推动香港法治在时间和空间两个尺度上的影响力。 既然我们回答完内地学生他应当建构对香港法律的信仰之后，我们可以来看最后一个问题：内地学生他应当如何去建构这样子的一种对香港法律的信仰呢？在此我就抛砖引玉，简单的提一下3个简单的路径。首先，第一条路径，我觉得也是最重要的路径，就是建构起正确的身份认同。在此，我想再次举一下那个麻将的例子。如果一个人他不打麻将，他也没有机会坐到麻将桌子上的话，他是不会有动力去了解麻将的意愿的。除非那个人要参加法治大会并做一个演讲，然后要引用麻将来证明法治的重要性。然后我们可以看到，一个成员他对于社会的认同感跟归属感是有助于加强他对于规则本身的认识以及认同的意愿的。而我觉得最关键是促进内地学生的身份认同从流动人口向这种香港人的身份的转变。我觉得这种转变也是可能的，因为香港人，我认为许多学者说的对，它是一个文化上的观念。许多人无论他们的出身、地域、肤色，还有他们的语言，只要他们相信自己是香港人的话，他们就是真正意义上的香港人。而这种认同感和归属感的话，将会有助于他们构建去认识规则并认可规则。而讲到了解并认可香港法律的话，我觉得关键点就是在于他们要认识到香港法律它与香港人民在利益和观念上面的契合点。这种共同利益以及共有观念化，将是他们构建对香港法律的信仰的重要基石。最后一点也是比较微观层面一点，就是根据沃尔兹提及的3个层面，他们可以通过对守法行为进行仿效学习，对守法行为以及违法行为分别进行正面评价以及负面的评价，从而来将法律规则以及对法律信仰内化为自己的观念，并通过同辈压力去影响自己身边的人。所以以上就是我简要提到的3个观点，很感谢大家的聆听，也希望香港法治越来越好。谢谢大家。
谢谢小道，非常感谢你那么有趣的一个分享，因为我们真的是之前也没有想过从那个建构主义还有打麻将的一个例子去理解香港的法治还有香港的法律，所以今天我相信大家会有一个新的角度还有那个新的层次的理解。谢谢。Moving from Hong Kong and Mainland's representative, may I now invite Glenda, who is a representative from Singapore, to share with us your insight on how to promote the rule of law in Singapore with us. Thank you.
Hello. Okay. Good afternoon, Secretary of Justice, distinguished guests, and fellow panelists. I'm very honored to be invited to speak today. And today I'm going to talk about some efforts that Singapore has made in terms of encouraging the rule of law and youth engagement in the rule of law. To this point, the presentation will have 2 parts. Firstly, we will talk about Singapore's stance towards the rule of law in the introduction section, as well as talk about the schemes that Singapore has used to engage youth, namely the mandatory pro bono hours requirement, as well as student-led pro bono projects, which has formed a very important part in engaging the youth. Firstly, Singapore has remained very committed to the rule of law. According to our Minister of Law, Mr. K. Shanmugam, he said that Singapore accepts rule of law as the foundation of our nation and that it is a universal value. To this point, the Singapore government has introduced many policies to encourage citizens to participate in the rule of law. Our first scheme that we're going to talk about is the mandatory pro bono hours requirement. Under this requirement, graduates from local law schools have to do 20 hours of pro bono work in order to graduate. For example, I come from the National University of Singapore, and we are required to do 20 hours before we graduate. And interestingly, this pro bono hours can only be logged after the first year of your law school career, which means that you will be able to have some skills, right, to help the local community. And I think this is also consistent with the Law Society's vision that law is a service vocation and not simply just a profession. This program has been rather successful. If you look at the statistics, 85% of individuals have indicated that they will provide pro bono services in the future. Considering that law students now are the future lawyers of tomorrow, this has effectively increased the amount of pro bono work that is being done in society in the future. And you might argue, oh, because it's mandatory, individuals might do it simply because it's compulsory. However, if you look at the statistics, a large percentage, in fact 72% of people, have actually completed more than the 20 hours requirement. It is submitted that this shows that Singaporean youth, through the mandatory pro bono hours requirement, have actually developed a love for pro bono, and this also contributes greatly to Singapore's rule of law. So why has this program been successful? I think it's very much reliant on student-run pro bono projects. For example, I was served as the project director of a pro bono project that basically collaborated with this organization known as the Financial Industry Dispute Resolution Center. So essentially, we were supposed to host workshops in order to educate the public on how they can protect themselves in disputes with financial industries. So we directed them to this organization that does ADR, settlement of such disputes. And I think that was a very fulfilling experience because we got to learn from the ADR professionals, as well as we were able to just, understand what are the problems on the ground. And I think that has made me a better lawyer and has also made me more willing to do pro bono in the future. So I'll just talk about briefly 4 characteristics of such pro bono projects. The first characteristic is that it actually involves a wide range of industries, legal industries. For example, I think the most interesting case is for military justice. If individuals are interested in military justice, they can actually participate in the military justice project and help military lawyers protect their clients in military courts. We also have collaborations with very prominent organizations. For example, the organization we partnered with, FITREC, is actually an organization directly under the Monetary Authority of Singapore. And this also allows law students to learn from very esteemed professionals in the legal industry. Moreover, it is student-led and initiated, which means that students are able to take ownership of their project, and this, I think, makes them feel a sense of ownership and belonging to it. The last thing is that it's feedback-driven. While professors, provide feedback, we also get feedback from our partner organizations as well as our participants. And this has allowed us to improve the project year after year. So in conclusion, the mandatory pro bono hours requirement has actually helped the rule of law in Singapore greatly and has greatly engaged the youth. Moreover, student-led projects have been very successful in terms of helping students feel connected to the rule of law. With that, I end my presentation. I thank the DOJ for giving me this opportunity.
Thank you, Glenda, for your sharing. And I think we all really like those student-led projects because it is a kind of empowerment to our young generation so that they can unleash their potential. And in the end, they can contribute back to the society. And for the mandatory pro bono hours, I think we don't really have that in Hong Kong. And maybe it is something that we can consider, right? Thank you, Glenda. And now it's Sin Shan's turn. Would you please share with us how Malaysia actually, in Malaysia, how the youngsters actually promote the rule of law?
Very good afternoon to the Secretary for Justice of Hong Kong, distinguished guests, fellow panelists, ladies and gentlemen. I'm San Shen from Malaysia. So today I'll be presenting on a topic entitled Roles of Youth in Upholding Rule of Law and Promoting Justice. Okay, so these are some of my background. So I'm also a law student and also a student leader. So I would like to talk briefly about the concept of rule of law, because I think rule of law is not just a principle governing one nation or territory, but it's a universal principle that governs us all. And rule of law is important because everyone is equal and accountable by the law. And of course, rule of law form the foundation to maintain and to regulate the conduct of the people in a nation in order to maintain peace and stability. And not to forget, rule of law is also a key element to achieve the Sustainable Development Goal, Goal 16 of the SDG, which are the peace, justice, and strong institution. Okay, so these are some of the key elements of rule of law that can be seen, like equality, independent judiciary, sufficiently clear, prospective, and also stable law, because law should be made known to the public. And also laws are made via lawmaking process, via legislative branch, and also preservation of human fundamental rights. For example, freedom of speech, freedom of expression, freedom of religion, etc., which form the cornerstone of the democracy process, and also access to justice and legal remedy. Okay, so Malaysia's efforts in upholding rule of law are, first of all, in the Article 4 of the Federal Constitution of Malaysia, is stated that Constitution is the highest law of the nation, and everyone is equal before the law under the provision of the equality. And also Malaysia will practice parliamentary democracy and constitutional monarchy, in which we have three branches of the government, namely the executive, legislative, and judiciary. So we don't interfere each other, but we work together to ensure the efficient government. And also we have the independent judiciary and equality before the law. So I would like to cite a case of Malaysia, which is Elma Nudo, a 2019 case, in which the principle is that a central tenet of the rule of law is the equal subjection of all persons to the ordinary law, in which we do not take into consideration the ranking, the hierarchy of the person, but everyone is equal before the law. And also fundamental rights are also protected in Malaysia, in which we have freedom of speech, just like every country, and also administrative body need to act within the ambit of law, okay, which is also part of the rule of law indicator, as you can see. The administrative body cannot act arbitrarily, they need to act within the scope of the law. So what are the roles of youth in upholding the rule of law? I would like to give a definition of the youth first. So in Malaysia, we define youth under the Youth Society and Youth Development Act. So basically in Malaysia, the latest amendment, the age of the youth was between 15 and 30 years old. And the United Nations defined the youth as 15 until 24 years old. So first of all, I think the youth should be actively involved in civil society organization, clubs and society in order to increase their exposure to the rule of law. So in order to do that, they can participate in more programs related to the law, about the nation building, so they can better comprehend the process when they are involving in the process directly. And also this is to provide a platform for the youth to appreciate the importance of rule of law in maintaining peace and justice. Because we know that there's a notion saying youth are the future leaders. But for me, I think youth are not just future leaders, but youth are the leaders of today. Because youth are having a lot of position, leading their student union in their own university. In Malaysia, we have the Youth Parliament. We also have the Youth Consultative Council chaired by the Minister, in which the youth can share their ideas directly to the highest administrative body. So I think youth are the leaders of today and tomorrow. Thus, we need to nurture, we need to groom, we need to build the capacity of the youth to be a well-rounded leaders. Second, I think the youth should be more proactive to become the ambassador of the rule of law, because youth are also playing an important role to become ambassador, to bridge the communication between the youth and also the community, in which the youth can actively organize program or to engage with the community to spread awareness regarding the rule of law, and also to improve the literacy and understanding of their peers regarding rule of law and also nation building. So how they can do it is basically organizing forum or academic discourse or any discussion that is close to the heart of the youth. They can discuss, among others, rule of law, SDG goals, and also international law, so that people can understand that it's also important for a nation to adhere to international standards and not just making law to the whims and fancy of one country. And also, as an ambassador of rule of law, youth have to know that actions speak louder than words. They cannot simply ask people to follow the law, but they break the law. No, you should set a good example by becoming a role model for all to follow the rule of law. And third, youth should be pioneer. They should start something. They should not wait and see. And they should organize more educational series and advocate for education of rule of law in formal syllabus or education system, because the youth should gain exposure and understanding and more knowledge about the constitution, legislation, international law, national legal system, principle of both common law and civil law, and the rule of law through various workshops and classes. So my idea will be having a mentor-mentee when the legally trained senior can become the mentor for the junior, which are the mentee, so that they can share their experience of working in the legal fraternity and also what is rule of law. So this is what I have done in my association and in Malaysia, in which form a mentor-mentee group in order to groom and teach the youth, especially the junior, about what is rule of law. And also we organize a lot of programs through extensive engagement to ensure that rule of law is incorporated in our daily life. It is not just very exclusive to a few. And of course, talking about rule of law, we are living in the prevalence of media and technology. So social media also play a very important role in which advocacy and education of rule of law can be conducted via various creative and innovative methods, as shown in this slide. For example, webinar, virtual information counter, and just to share Malaysia, also we have the e-filing system in which lawyers need not to go to court, but they can file their document submission on the e-filing system. And also we have the e-saman, in which people can pay their fine via online system and also online hearing. And all these are the utilization of the technology and also social media to promote justice and also understanding of rule of law. So last, I would like to urge all the youth to do comparative analysis on the rule of law indicator. As we know that every year, the World Justice Project will have the rule of law indicator. So as you can see, they will judge the rule of law of each nation based on a few indicators, like accountability of a government, transparent justice system, order and security, access to justice by the public, independent judiciary, and also preservation of fundamental rights. So the youth, what they can do is basically to analyze what is the ranking of their country and the ranking of those countries in top 20, let's say. So they can understand better which part of it that their nation should be improving. For example, Hong Kong is good in order and security, less corruption. So the youth in, let's say, this nation can learn how they can follow the good example step by Hong Kong in order to get a higher ranking and also to improve the rule of law indicator in their own nation. So last but not the least, I would like to have a message for all the youth and as distinguished panelists and also all participants today, in which youth should be regarded as a stakeholder of the world. We, the youth, are the leaders of today and tomorrow. We must take charge now and be proactive in contributing our ideas and effort, as all of us will one day inherit the world. Soon, and also slowly but surely, thus, we must start now in order to better prepare ourselves for the future. As they always say, we need to future-proof. So we need to be active in building a peaceful, sustainable, and prosperous world for us and also for the future generation. So that's all. Thank you very much.
Thank you, Sanshin. Thank you for giving us the Rule of Law 101 in Malaysia's context. And I'm glad to see that all our speakers actually in this panel session today, including yourself, has actually put your points into practice, because we are all the ambassador of the rule of law and we are all pioneering in advocating the education of rule of law at the community level. And we wish to conduct more like community outreach programs. And in respect of digitalization, I think it is more relevant to the last presentation that is going to be given by Jason. 或者我哋而家就請 Jason 去為我哋講一講，其實我哋而家科技係點樣可以幫助我哋去做法治推廣，好唔好啊？有請 Jason。
好，律政司司長、各位來賓，你哋好。咁其實我講少少故事先啦，我哋都去到尾聲啦，呢度大家都可能聽到有啲攰。究竟一開頭我俾人 invite 嚟呢一個嘅panel，其實我有啲 surprise 嘅，因為我本身係冇一個 legal 嘅 background 啦。咁我究竟會唔會係即係唔夠一啲嘅 knowledge 去講到需要講嘅內容咧？咁但係當我睇一睇嗰個嘅主題咧，我就覺得恍然大悟啦。因為呢一個咧正正就係講緊我係提倡緊一個嘅direction， 就係其實 rule of law 同埋一啲 legal 嘅 concepts 係應該普羅大眾咧都係可以明白到，都可以用到，唔局限於一啲係修讀 law 嘅同學或者啲律師先至會識嘅嘢。咁我嚟緊咧就會分享一下關於即係可能一啲年青人啦，尤其是點樣可以幫助佢哋真係可以係了解到一啲咁樣嘅 concept， 去應用到佢哋第日嘅成長入邊，同埋去唔同嘅行業入邊咧。咁或者開始之前，我都問下大家一個問題啦，大家可以一齊諗下，就係究竟而家嘅年輕人係點樣諗 rule of law 呢個 term 嘅咧？咁嗰時喺準備呢一個嘅 panel， 我都有去訪問過唔同一啲嘅朋友啦，佢哋都嚟自唔同一啲唔係 law 嘅行業入邊嘅一啲大學生。咁其實咧，我哋可以一齊睇下，係啦，我哋就揀咗幾個 adjective 係最 common 最多人揀嘅。你見到啦，係好悶啦，係啦，一啲好 technical 嘅嘢啦，一啲好難理解，一啲好虛嘅 concept 嚟嘅。咁其實呢個一啲都唔出奇嘅。對於一啲普羅大眾，甚至乎一啲小朋友嚟講咧 ，rule of law 的確係比較抽象，唔係咁容易理解，甚至乎好多人未必即刻答得出係乜嘢嚟嘅。咁其實究竟我哋係咪應該可以好多喺教育方面嘅方法，可以幫助大家容易啲理解到呢一樣嘢咧？又或者好似呢一個 PowerPoint 咁樣啦，大家都見到。風格同朝早嗰啲有少少唔同，係啦，其實呢個就係特登嘅，因為我哋希望有一個年輕化啲嘅一個 presentation 之餘，就係突顯翻呢個嘅主題。其實學習一啲比較 technical 嘅 rule of law 嘅 concept，都一樣係可以咧做到一個好簡化嘅方式，去俾一啲嘅可能學生啦，或者一啲嘅年輕人容易啲吸收去理解到。咁究竟我哋點樣可以有啲咩創新呢個方法，或者啱啱所講一啲 digitalize 嘅方法係可以推動到呢一樣嘢嘅咧？咁我有個三部曲嘅諗法，就係3個 E 字頭嘅字 ：educate、engage 同埋 execute 嘅。咁嗱，首先我哋需要想呢個年輕人係可以幫手 uphold 到 rule of law， 當然就先要佢哋明白係咩嚟啦。咁所以我哋就一定由教育開始嘅。係啦，咁我咧就自己係非常之對一啲教育科技有興趣，而我相信一啲比較複雜嘅 concept， 例如係 rule of law 嘅課題咧，如果我哋可以有一啲好有趣、好好玩嘅方式，去俾一啲嘅年輕人去接觸，其實係會令到佢哋更加有興趣，真係深入了解、自發性去學多少少嘅。因為可能以往啦，大家都會想像到呢啲咁樣嘅 concept， 我哋只會可能喺教科書上邊啦，有一啲嘅一兩句嘅硬知識去俾佢哋去學一學。但係其實佢哋未必真正係可以了解到日常生活點樣應用到落去。又一次好似啱啱啲 panelists 都有提及到，其實可能各行各業嘅人都對 rule of law 呢一個嘅解讀咧有少少唔同。咁究竟我哋係咪真係可以用一啲文字上面就可以完全灌輸到呢啲嘅概念俾佢哋咧？而我認為一啲教育科技，例如係一啲遊戲化嘅一啲學習方式咧，係會非常之有效嘅，因為我哋係可以真正將呢啲嘅概念咧融入喺一啲佢哋日常生活遇到嘅情況入邊啦。係啦，咁我哋就可以用一啲嘅 simulation 嘅遊戲，俾佢哋嘗試喺日常生活唔同嘅一啲嘅情況，例如係好似啱啱今朝有啲 panel 都講到。係可能同 NFT 有關嘅，可能而家好多嘅年輕人都有興趣啦。其實同佢哋去睇一啲嘅藝術嘅展品，或者佢哋做一啲可能喺 NFT 上面嘅一啲嘅 trading 嘅時候，究竟背後都牽涉咗好多一啲 contracts 啦，好牽涉到好多 rule of law 嘅一啲嘅 concept 喺入邊。咁就由一啲佢哋有興趣嘅課題開始着手，去俾佢了解呢個係一個好有效嘅學習方式嚟嘅。係啦，咁另外啦，都可以用一啲嘅 hands-on 啲 experience。其實啱啱 panel 都講咗好多啦，咁我都唔重複太多啦。咁但係一啲比較互動性嘅方式咧，先至可以俾佢哋親身去體驗到。如果唔係，就好似啱啱一開頭所講啦，其實 rule of law 一個比較好 distant 一個好遙遠嘅概念嚟嘅，要令到佢哋真係可以透過親身嘅感受同埋體驗咧，先至更加有效可以掌握到相關嘅一啲嘅 concept 啦，俾佢哋去了解多少少嘅。咁一啲例子啦，就係譬如俾佢哋去明白到，可能係喺一啲唔同國家入邊、唔同地方入邊，其實 rule of law 都可能有少少唔同啦，同埋可以俾佢哋去參與一啲，譬如係知道，譬如法援咁樣，我哋講緊係唔同嘅人啦，無論可能佢唔同嘅種族又好，佢可能係唔同嘅經濟能力都好啦，都一樣有同樣嘅權利嘅喎。咁呢一啲都係我哋可以透過一啲好日常化嘅例子去俾佢哋去了解到嘅。係啦，咁可以分享一下，其實我哋有啲咩內容係可以俾佢哋簡化啲咁樣去學習到關於 rule of law 嘅嘢咧？咁首先就係講到唔同嘅行業啦。啱啱今朝嘅 panel 都有講到啦，其實 rule of law 並唔係單單喺呢個嘅法律嘅行業嘅界別入邊先會牽涉到嘅。喺我哋唔同佢哋學生長大之後啦，去到唔同嘅行業去做嘢嘅時候，其實都息息相關嘅。可能係今朝講到一啲嘅同物流啦、啲 shipping 上面嘅嘢啦，可能係藝術展品啊等等，其實各方面都牽涉咗好多。 咁可能對一啲中學生嚟講，佢哋或者大學生嚟講啦，佢哋即將都會去準備自己喺唔同嘅行業入邊嘅個 career 嘅發展嘅時候，都可以了解到原來 rule of law 咧都係一個好重要嘅角色。咁當然啦，我哋就係分開到唔同嘅持份者都可以俾佢哋明白到嘅。例如作為一個普通嘅市民嘅一個角度啦，可能佢哋係一個嘅 employee 嘅時候，佢哋做緊嘢嘅時候，去做啲乜嘢係可以幫手 uphold 到 rule of law 嘅咧？甚至乎可能佢哋第日成為社會嘅棟梁，喺呢一啲嘅各大嘅機構或者公司嘅時候，點樣可以都係符合住呢一個嘅 rule of law 嘅原則，去確保我哋可以一齊去幫香港呢個社會係去發展咁樣咧？另外就係香港嘅獨特性啦，我哋大家都知道係香港係一個好獨特嘅一個嘅地位啦，有一個一國兩制嘅制度之下，其實我哋享有呢個 judicial independence 呢一啲概念咧，其實都可以係簡化咁樣去及早俾唔同嘅學生去了解，透過啲遊戲知道原來咧我哋係有唔同一啲 check and balances 嘅機制啦，去令到我哋可以喺一個咁樣嘅環境度去發展嘅。咁我哋最終嘅目標其實咧，因為相信教育一定唔係一啲一時三刻會完成到嘅，係一個好漫長嘅 process。但係我哋大家都需要及早開始嘅。其實好希望我哋可以透過多啲灌輸呢方面嘅概念咧，係可以幫到而家嘅年輕人，亦都係將來社會嘅棟梁啦。佢哋去知道點樣可以去 abide by the law之餘咧，亦都可以明白其實點解要咁樣做，背後嘅意義喺邊度咧？呢個係非常之重要嘅，就唔係單單去背誦咗一啲嘅知識之後就照跟咁樣啦。咁我哋希望佢哋可以做到咧，就係佢哋親身明白到個重要性，係同埋都會尊重呢一個嘅 rule of law 嘅。咁去到佢哋去長大嘅時候啦，都可以幫手再去推廣 rule of law 呢個概念俾佢下一代同埋喺各行各業入邊嘅。係啦，咁就啱啱呢度講到我哋3個嘅 E 字頭啦，有 educate 啦，咁 engage 其實就希望係可以多啲俾佢哋親身去參與嘅。如果佢哋有好多唔同嘅睇法嘅時候，其實佢哋都係有一個年輕人啦，而家都好多機會係可以有自己嘅聲音嘅喎。就例如係啦，最近呢幾年啦，我哋好興提及嘅一啲嘅青年嘅佢哋嘅委員會，佢哋可以自薦咧，去喺唔同嘅界別度都發表佢哋嘅意見，就係可能一啲措施方面去開始啦。咁呢啲都係可以幫手咧，係令到佢哋參與多少少嘅。咁最後講到嘅 execute， 其實呢個咧並唔係我哋呢一刻係做嘅嘢嚟嘅。我哋希望喺透過推廣呢個嘅法治教育之下咧，第日年輕人咧，佢哋係會成為社會嘅棟梁嘅時候，佢哋係會利用佢自己所學嘅經驗啦，去推廣呢樣嘢出嚟嘅。係啦，咁最後我深入一下啦。啱啱一開頭大家都見過幾個唔同一啲嘅諗法、一啲嘅形容詞，好希望其實我哋可以透過去推廣呢一方面嘅知識咧，我哋係可以令到而家嘅年輕人啦，佢哋係會認為 rule of law 其實係一個好 hopeful、好正面，亦都係好容易理解、好容易學到啦。係啦，係好有趣啦，同埋係同自己息息相關嘅一個嘅課題嚟嘅。因為呢樣嘢其實應該係俾普羅大眾，尤其年輕人啦，都係需要及早接觸到，而佢哋都應該係知道 rule of law 喺香港有咗一個好重要嘅一個 role 係 to play 嘅。咁可能完之前都想引用一下啦，就係 Lord Bingham 咧都講過，就係其中一個8大原則入邊咧 ，law 係應該係 intelligible 嘅。咁所以我哋好希望可以將一啲看似好遙遠、好深奧嘅概念咧，係推廣俾更多年輕人嘅。多謝。
唔該晒 Jason 嘅分享。好啦，因為今日咧，其實我哋個時間咧只係去到5點3嘅啫，咁我都俾大會圈緊啦，咁所以我而家都唔講咁多，直接咧就落去 Q&A session 啦。好，我哋不如問咗第一條問題先啦。呢個問題咧，其實就 direct 俾阿 Kelvin 同埋阿 Angel 嘅。有人問咧，就係話，如果我哋香港有一啲年青人，或者可能外國有啲年青人啦，佢哋真係好有興趣去推廣法治，咁你哋會唔會有一啲 tips，或者有一啲建議咧？如果佢哋真係想參與嘅時候，喺香港或者喺海外，究竟可以點樣做咧？
其實我覺得我同年輕人傾偈嘅時候咧，我覺得大家對於法治呢個定義咧，其實都未真係確認得到嘅。咁再加上就係其實大家好似對呢個法治呢一個字眼啦，佢哋唔會同佢哋身邊嘅人去探討。咁所以我覺得其實第一樣嘢佢哋需要做嘅咧，就係將呢個定義咧定咗落嚟，跟住再同各行各業嘅人傾呢一個法治呢一樣嘢嘅時候咧，去再重新去睇一睇究竟佢哋自己嘅定義啱唔啱先。咁當佢哋確立咗佢哋自己認為個法治係點樣嘅時候咧，跟住再去同即係可能香港啊，或者甚至去到外國嘅時候咧，都會將呢一個法治呢一個意思咧，去同其他人去探討，從而去將我哋香港呢邊嘅法治去傳出去俾其他人去聽咯。
好 ，thank you Kelvin。咁啊，Angel 有冇補充？
係我都有啲補充嘅。咁其實頭先聽到 Glenda 嘅 presentation，I like your presentation very much。咁都有提過呢個 pro bono 嗰啲 programs 啦。咁我覺得如果係講緊法律嘅修讀法律嘅學生啦，其實喺在學嘅時間亦都可以參加更加多呢啲pro bono 嘅 program。雖然而家唔係話必須要做，但其實趁住真係未有咁多負擔嘅時候咧，去參加多啲 legal clinic 嘅嘢啊。咁將來就算係畢咗業之後，亦都可以繼續去做啲 legal advice 嗰啲咧。我認為呢樣嘢係就係將 rule of law 可以普及化嘅其中一個方法。
好 ，thank you Angel。我们也收到另外一个问题是给小道的，就是说，观众想问一下，那你觉得香港的港漂还有内地的学生是怎么可以去影响或者是推进，在香港的那个法治的发展？
好，感谢这个问题。然后这是个好问题，然后它还跟我的 PPT 密切相关，那我就借用一下我 PPT 的那个 flavor 来解答这个问题啊。我觉得简而言之，其实一个内地学生或者说俗称的港漂，他只要成为一个具有法律信仰的守法公民，我觉得这就已经足够了。因为在原因方面的话，根据结构化的观点，香港法治其实可以被视为一种是符合法律的社会实践，所以社会成员本身的观念跟他的实践的话，本身就能够为这个实践来做出贡献，而且它还能够影响其他社会成员的观念跟活动。所以我觉得，内地学生他只要发挥好自己在时间还有空间上面的这种特殊的优越性，然后比如说在时间方面的话，如果他只在香港停留短时间，那他只要尊重法律、遵守法律那就够了。如果他是停留长时间，甚至成为永久性居民的话，那他可以有充分的时间去了解具体的香港法律，然后为立法、执法还有司法去提供一些针对性的完善意见，从而推动法治。那在空间的话，我觉得他可以使用像我 PPT 里面提到的引用的沃兹提到的3种社会化的方法：模仿学习、给予正面的社会评价、负面的社会评价这种方式来去影响在内地还有在香港的不同的人群。这样子的话，我觉得就足够为法治做出重大的贡献。虽然很日常，不过我觉得日常生活也可以给香港法治做出重要的显著的影响，因为香港法治它本身就是我们的日常生活的一部分了。谢谢。
好，谢谢。This question is directed to Glenda and is actually a very long question. And I try to read out slowly so that you can try to understand it. When was the pro bono requirement for university students introduced in Singapore? Is there any observable change in the pro bono practice, culture among Singapore legal practitioners afterwards? The question is whether the pro bono culture translates from a school context to a work context, where there may be fewer opportunities for lawyers to create their own pro bono projects.
All right, thank you for that question. I think the pro bono requirement was actually introduced, I think, in 2014. It was not a very long time, so there hasn't been a long enough time for us to concretely observe the effect of it. But I do think that there has been a difference in the legal community after it was introduced. So I think the Law Society a few years back has been considering on whether they should include a mandatory pro bono hours requirement for registered lawyers. And I think in the end they decided not to, but right now they recommend that lawyers do at least 25 hours of pro bono. I think in Singapore at least, from my experience, many lawyers are actually very willing to do pro bono. We have things like lawyer clinics and other activities that lawyers participate in. I recall there was a partner in one of the top law firms in Singapore that told me that to her, pro bono was a very important part of giving back to society. So I think to that extent, pro bono has become a very important part of the lawyer community. And so I think the mandatory pro bono requirement does have an effect on legal culture after school.
Thank you, Glenda. 好，下一題咧應該係 direct 俾阿 Kelvin 嘅。 有觀眾就有問到啦，而家咧我哋好似年青人同埋可能機構團體中間都可能會有一啲不信任啦，咁佢哋又可能會覺得而家究竟我哋可能喺個決策上面嘅過程裡面，可能佢哋又會有一啲誤解喎。咁究竟我哋作為推廣法治嘅年青人，咁又應該點樣可以處理呢一個中間嘅不信任呢？
呢個係一個好複雜嘅問題啊！咁我覺得其實主要都係嚟自教育嗰方面嘅，即係我覺得個社會個機制啦，即係喺我經驗嚟講，其實我較年輕嗰陣時，其實我都未明白個機制嘅。咁喺嗰個時候，我都會覺得點解即係好多時候，我覺得應該好簡單可以做到啊，點解做唔到嘅？咁但係當我踏入咗社會之後咧，開始明白個機制咧，其實就慢慢就已經會接受得到嗰個社會機制。咁所以我覺得就住喺年輕人嗰方面咧，如果我哋可以俾多啲機會，例如好似我哋 law 所入邊嘅 Teen Talk 咁樣啦，去俾佢哋有呢啲嘅模擬嘅試下喺嗰個立法會度去傾個 legislative bill 又好啊，點都好，喺度俾佢哋知道有個商討過程，有一個時序嘅情況之下咧，我覺得即係呢啲嘅誤解就會可能化解得到咯。
好 ，thank you, Calvin. This question is directed to both Glenda and Sanchin. Perhaps this time gentleman goes first. How is the rule of law taught in Singapore and Malaysia? And has it been included as a subject in the elementary or secondary schools?
Okay. Rule of law is taught in Malaysia. There's a subject known as general study. So a basic introduction of the rule of law, like the concept, the national system, as I said, the parliamentary democracy and the constitutional monarchy, and also our constitution as the highest law. All these values will be included in the syllabus. But of course, I would advocate for a subject maybe known as law study, general law study, starting from younger generation. Maybe you can start in primary school, so they can understand the law better, how the law can influence themselves, and also how they can involve in the legal process. Maybe they can go to field trip, visit to parliament, to see how the bill is presented, tabled, and also debated, to see the full process, like the first reading, second reading, third reading, until the passing of the law, so they can feel that the law will be having an impact on them, and also truly understand the principle of the law. And I will advocate also for a simulation. Maybe they can do like a simulation of the process in the school. Any regulation that involves the student, maybe they can discuss with the student, engage with the student, so to let them know that rule of law is actually promoting democracy and discussion in which between the government and also the citizen. Thank you.
So do the students in Malaysia take this subject very seriously?
Yes, it's a compulsory subject to take if you are taking Form 6 in the secondary school. So this subject is a very important subject. As a citizen, I think everyone is compulsory to know and to understand the law because it governs all.
Okay, it sounds good. How about Glenda?
Actually, we have a pretty similar system. So at least in the secondary 4 level, all students are actually expected to take this subject called social studies. And the social studies actually includes things about how our government operates, perhaps policy objectives. And so through that, they can understand a bit more about the rule of law. But I do realize that at least within the secondary school elementary levels, we do not explicitly mention the subject of rule of law or the separation of powers. In fact, oftentimes it's considered extra reading, and generally people don't take it that seriously. So I think that, at least for me, I was only truly formally introduced to the rule of law through law school. And I think that's a shame because the rule of law is really a fundamental value of Singapore and has been enshrined in the Singaporean constitution as well. So I do hope that Singapore can do a bit more to educate young students about it and ensure that Singaporeans can exercise their civil liberties.
So is there any rule of law promotion program or initiative to the general public in Singapore generally?
And not that I know of. So generally what we have instead is legal awareness workshops or programs educating the public on their rights when they're dealing with certain issues. So I think that is the limit of what Singaporeans are exposed to, which is why I think more can be done in this regard.
Thank you for your sharing. 其实这个我都有兴趣了解一下，就是在内地，如果要推广法治的话，那在那个社区的层面，或者是就是大众市民的层面上面，其实从国家或者是政府的角度来看，有没有什么 initiative， 或者是有没有什么计划？
既然提到社区的话，我着重点讲一下社区民间层面的活动吧。其实我在本科学校还有在硕士的时候都有在法源协会里面工作过，就发现是基本上在大学里面的他们的法律学院都会有法律援助的中心，然后他们都会组织面向学生的还有面向普罗大众的那种普法活动。我觉得这也是一种社区自发的很重要的一种宣传法治的方法，因为法治的大家一般认知法治最重要的基础就是先让大家去认识法律、了解法律，然后这才是构建起那个法律信仰的这个基石。我觉得这一点的话，在社区层面已经做得不错，然后我觉得还可以进一步发展，就是国家也可以进一步投入更多的关于律政相关的、包含法治精神相关的文娱作品，然后这方面的话，它可以影响到更大范围的群众，让他们树立起那种以尊法为荣，然后违法为耻的这样子的观念，这也对于法治有重要的影响。谢谢。
好，謝謝。下一條題目咧就係俾阿 Jason 嘅。咁咧頭先你分享咗個好得意嘅概念，就係一個 gamified learning 啦。咁有觀眾咧就想問啦，gamified learning 咧其實就係幫助喺即係我哋嘅新生代嗰度推廣法治啦。咁如果係真係一啲好細嘅小朋友，好似真係幼稚園或者小學生咁樣，咁其實又點樣可以應用到呢個 gamified learning 呢個 concept 咧？有啲咩遊戲可以俾到佢哋玩？會唔會有一啲例子可以講到咧？
冇錯。咁其實正係 gamified learning 咧，佢係最主張喺一個遊戲當中咧，一個好快樂一個形式咧，去學習一啲唔同嘢。咁其實對一啲尤其是特別細嘅小朋友啦，可能講緊係小學甚至乎幼稚園咧，都會係一個好好嘅方式俾佢去開始接觸呢啲嘅概念嘅。咁當然啦，我哋喺呢啲嘅應用上面，我哋就唔會用一啲好深奧嘅一啲字眼，我哋一定會用翻啲 layman 啲好簡單嘅 concept 俾佢聽。咁但係就可以由一啲好日常嘅例子啦，即係簡單至就可能係佢哋都會知道，可能有唔同嘅呢啲角色啦，喺社會入邊，可能佢喺一個班房嘅 setting 入邊嘅，係啦，可能係有同學去犯咗校規咁樣，咁究竟佢通常係有啲咩嘢嘅責任啊，或者係通常會點樣處理？咁可以將一啲比較複雜嘅一啲可能係同 rule of law 有關嘅 concept 滲透喺一啲佢哋好容易去吸收到一啲好簡化嘅方式去 show 俾佢睇。咁而佢嗰個形式咧，亦都唔係就咁去齋去背一啲嘅，而佢真係去嘗試代入個角色入邊，因為 simulation 嗰個位就係佢可以係模擬翻唔同嘅角色，佢哋會做唔同嘅行為嘅時候，咁究竟佢哋嗰個結果係會點樣咧？又或者有啲乜嘢嘅 option 就會出現到咧？咁呢啲都可以去幫佢及咗佢有呢個概念去學到。咁所以相信真係一啲嘅遊戲化嘅學習都好適合一啲比較細嘅學生嘅。
好 ，thank you，唔該晒 Jason。因為時間嘅關係啦，咁我其實就有最後一條問題都想問大家嘅。Actually, I have a roundtable question for each of you, and I would like to know, what is your short answer when you see the question? What is the rule of law? Could each of the speaker do a very brief sharing? Let us know why. Can we start with Kelvin? Kelvin， 你先啦。
我諗即係如果一個 short answer to what is the rule of law 嘅話，我覺得我會話係司法獨立，呢個就一定係即係最重要嘅一個概念嚟嘅。咁即係呢一樣嘢係要大家都認知乜嘢係真正係司法獨立。咁呢一樣嘢係要你自己住喺嗰個社區，你先至會知道同埋明白嘅嘢咯。
好 ，thank you Kelvin。不如等 Angel 都講下。
咁我會講 equality 平等嘅，咁唔係淨係講緊平等嘅權利，而係其實大家對於成個法制等等嘅 understanding 都要係一致嘅。
好 ，thank you Angel。So next one, Sanchin.
So I think rule of law is a concept that protects everyone, their fundamental rights, and also equality before the law. So in order to do that, we need to ensure independent judiciary to execute the task to ensure that their right can be protected and the nation will be peaceful. And for that to happen, all citizens also play a role, not just to promote justice, but also they should play their part by adhering to the rules and regulation, becoming a good citizen. That's all.
Thank you, Sanshin. How about 小刀？
谢谢。然后老师说我在见到 rule of law 这个概念的时候，其实我是先接触了吉登斯的那个结构化理论，所以我第一反应就是这不就是吉登斯那个 situational theory 里面的内容吗？那简单的回答，我觉得就是，我觉得所谓的法治，就还是像我之前说的那样，在一个社会里面较长的时空范围尺度所形成一系列的符合法律的社会活动，无论它是否与立法、执法、司法相关，只要它的行为体，它坚信的行为是 符合法律，并怀揣这种观念来实施的一系列的行为或者观念或者话语的话，我觉得都可以属于法治的范畴。谢谢。
好，谢谢。How about Glenda?
I think to me, rule of law is essentially access to justice. I think as many speakers today have pointed out, you can have the most perfect legal system, but if individuals are too poor or too uneducated to access the legal system, then the legal system may not function as properly as it should to protect rights, which is essentially the purpose of the legal system.
And Jason?
咁大家講咗好多唔同嘅一啲 principles 啦 of rule of law， 咁或者我宏觀啲再講下就係、其實 rule of law 應該就會係幫助啦香港啦 especially 係去做一個嘅 bedrock for success 嘅，咁佢係即係貫穿唔同嘅行業、唔同嘅年紀，其實喺我哋日常生活都係滲透住呢個概念。如果我哋可以 uphold 到 rule of law 呢樣嘢咧，係可以幫助我哋一個社會嘅發展去作為一個好重要嘅 foundation 咁樣嘅。
好 ，thank you 啊 Jason。其實咧，我都想有少少分享，就係、當我咧問我啲朋友嘅時候，聽到法治或者 rule of law， 你哋諗到啲咩咧？咁竟然咧幾 interesting， 我見到有幾個 young lawyers 咧，佢話第一樣嘢 come up in 佢哋個 mind 咧，竟然就係律政司 ，the Department of Justice。咁所以咧，我相信咧法治呢個咧，真係同我哋律政司 Department of Justice 咧嘅關係就真係非常之密切啦。 咁因為今日時間都夠啦，我都多謝咁多位 speaker 啦，亦都 thank you very much Department of Justice for making this happen and we look forward to seeing all of you in the next event. Thank you.
Thank you， 再一次用最熱烈嘅掌聲，多謝我哋嘅 speaker 之外啦，當然我哋嘅主持人 Sharon。喺呢個時候，不如咧大家繼續保持就座先，係啦，跟住望住我哋正中間嘅大會攝影師一齊影翻張相啦。咁剛才咧呢一個 專題研討環節真係非常精彩啊！因為咧，等大家啦都可以更加了解到啦年輕一輩嘅諗法㗎。喺度再一次多謝晒 Sharon、Kelvin、Angel、Glenda、Sanshin 同埋 Jason 以及黎先生嘅分享 ，thank you， 多謝晒。我哋咧有請台上咁多位可以稍移玉步到台下就座啦。 其實唔經唔覺啊，我哋1連5日嘅香港法律週2022咧，嚟到呢一刻已經嚟到尾聲啦。咁其實啱啱咧，我哋第3場嘅專題研討咧，係一個好特別嘅環節嚟㗎，因為我哋大家除咗聽到年輕一代喺佢哋唔同崗位 嘅上面啦，點樣喺社區做到各式各樣嘅法治教育嘅分享，帶出點樣可以將法治教育普及化之外啦，亦都聽到年輕一代啦，佢哋點樣集思廣益、共同商議，點樣更加好咁樣促進法治喺社區扎根㗎。咁當然啦，我記得啦，其實點都離唔開啦 Jason 提及到3個 E 㗎，咁包括 educate 啦、engage 啦同埋 execute 㗎。咁今日咧，希望透過我哋嘅法治大會、法治公義普惠共存啊，好似剛才啦司長喺我哋今日開幕詞入面所提到，我哋好重要，希望傳遞一個好緊要嘅訊息，就係 法律同法治咧，其實同我哋每一個人都係息息相關，而每一個人呢，都有鞏固同埋維護香港法治呢一個重大嘅使命㗎。咁嚟到呢個時候啦，我哋咧今日嘅活動已經接近尾聲啦。喺呢個時候，我哋有請中華國香港特別行政區政府律政司副司長張國根 SBS JP 嚟到台上面為我哋致閉幕詞。我哋有請副司長。
司長， 各位嘉賓、各位朋友，大家好。不知不覺咧，我哋今日嘅法治大會咧已經咧係嚟到尾聲。今日法治大會嘅嘉賓咧，可以話咧係星光熠熠。除咗今朝早我哋有國際統一司法協會秘書長 Professor Tirado 作為我哋嘅主題嘉賓，分享有關法治咧點樣係可以促進我哋可持續發展之外咧，更加係有我哋律師會陳澤銘會長，以及咧香港大律師公會杜鑑坤主席咧，為我哋主持呢一個嘅專題研討會，分別咧同我哋多位星級嘅嘉賓咧，係分享有關法治點解係我哋香港各行各業成功嘅基石，以及咧係探討多元化嘅爭議解決機制、未來發展趨勢等等呢一啲重要嘅議題。我哋今日參與討論嘅嘉賓有我哋終審法院鄧國晶大法官，我哋有香港國際仲裁中心主席袁國強資深大律師，同埋我哋香港故宮董事局嘅主席譚允芝資深大律師，帶領我哋咧去探討點樣係優化完善我哋爭議解決嘅機制。完善多元嘅解決爭議機制，的確咧可以為我哋社會各界嘅人士咧係提供可負擔嘅、有效嘅同埋及時嘅法律同埋爭議解決服務。呢一個係十分重要嘅一個法治嘅元素。香港，我哋作為領先國際嘅法律同埋爭議解決中心，實力係毋庸置疑。我哋匯聚咗唔同文化背景、唔同專長嘅國際法律同埋爭議解決嘅人才，為有需要嘅個人或者咧係企業係提供優質嘅多元嘅法律同埋專業嘅服務。我哋亦都擁有穩健嘅法律制度同埋配套，深厚嘅法治嘅基礎，亦都咧係得到我哋國家大力嘅支持，又同我哋國際社會咧係緊密相連。另外，我哋香港係眾多國際律所同埋國際法律組織落戶之選，亞洲、非洲法律協商組織嘅區域仲裁中心選址喺我哋香港呢一個法律嘅樞紐，並啱啱咧喺今年5月咧係正式咧係開幕。知名法律相關嘅國際組織所帶嚟嘅協同效應，可以為我哋香港係創造更多嘅機遇。當然啦，最近另外一個大好嘅消息就係喺我哋國家支持之下，國際調解院嘅籌備辦公室咧將會喺香港咧係成立。呢一個機構咧係為我哋國際爭端提供一個經濟同埋有效嘅一個調解新平台，補充咧現有國際爭議解決嘅機制，對於促進我哋國際爭端嘅和平友好解決，以及維持各國際主體之間嘅友好交流同埋合作，意義重大。呢一個辦公室將會喺明年咧係開展同埋相關嘅籌備工作，而佢選擇喺香港成立有關嘅辦公室，正正就係反映外界對我哋香港作為亞太區國際法律同埋爭議解決服務中心充滿信心。除此之外，唔能夠唔提嘅就係今日專題研討會咧，更加有幾位係嚟自唔同專業界別嘅翹楚。我哋今日唔單止係從法律嘅角度探討法治，更加透過我哋幾位嘅嘉賓佢哋嘅真知灼見同埋專業知識，帶領我哋咧從金融、海事行業、創新科技行業、文化藝術行業等等嘅視角咧，係了解法治對各行各業嘅重要。正如司長咧今朝早上致辭所講，無論係國家嘅14、5規劃，抑或咧係大灣區發展規劃綱要等等嘅國家嘅戰略，都反映出咧國家對香港嘅堅實支持，為我哋香港係注入源源不絕嘅發展動能。 14五規劃更加係確立咗我哋香港8大中心嘅定位，包括咗法律及爭議解決、金融、航運、商貿以及新興嘅產業，好似航空、創新科技、知識產權以及係文化藝術。值得留意嘅係我哋法律及爭議服務，其實同我哋香港8大中心嘅地位可以話係密不可分。並且係起到相當重要嘅支持作用。眾所周知，我哋香港作為國際嘅金融中心嘅領導地位，係因為係有健全嘅一個嘅法律同埋監管制度作為呢一個嘅支撐。而無論喺航運、商業、航空、創新科技等等唔同嘅產業都會係牽涉到種種係唔同類型嘅合同嘅定位啦。對我哋各種合法權益嘅有效保障啦，以及一旦係遇到爭議嘅時候，各方都能夠係有效、公正嘅解決。至於我哋香港喺知識產權嘅貿易、文化藝術同埋創意產業方面嘅發展亦都有賴於我哋香港同國際接軌嘅知識產權保護制度，以及完善多元嘅解決爭議機制。另一點不得不提嘅係，我哋香港依據基本法保留嘅普通法嘅制度，係我哋國家唯一實行嘅普通法嘅一個司法管轄區。普通法嘅制度能夠因時制宜咁樣係適應需求，並且廣為我哋海內外嘅商界同埋投資者係熟悉。香港更加係擁有悠久嘅普通法傳統。我哋嘅普通法制度公開透明、務實，兼且係獨立，並且係建立咗完善嘅商業嘅案例法，享譽國際，令到我哋香港係可以得以全力發揮背靠祖國、聯繫世界嘅呢一個嘅優勢。除此之外，今日嘅法治大會另一個亮點就係壓軸嘅一個專題嘅研討會，探討有關我哋年輕一代推動法治普及嘅重要角色。呢一節嘅研討會唔單止大家剛才見到啦，由我哋香港青年嘅法律人所主持，講者更加係我哋後生仔女嘅天下，包括新晉律師、大律師、國際青年法律交流會嘅得獎人、年輕嘅學者，以及係傑出大專學生嘅代表等等，帶領我哋與會者係從我哋青年人嘅視角去了解青年人參與法治工作嘅努力，以及係睇下佢哋點樣係跳出我哋傳統嘅框框去推動呢個法治嘅教育。例如剛才大家已經聽到㗎啦，透過創新嘅科技、遊戲嘅方式，以及係模擬社會實況嘅一啲個案嘅形式，將呢個法治嘅概念以一個輕鬆易明嘅一個嘅手法係帶入去年輕人嘅世界。又例如剛才所講，法律系嘅學生係需要係有一個自己主導嘅法律嘅項目，並且要完成最少20小時嘅義務法律工作，先至能夠係畢業。嗱，呢一啲嘅經驗嘅分享十分難得，對我哋思考將來如何推廣我哋法治嘅工作可以話係帶嚟正面嘅衝擊。我今日選擇用廣東話係作為呢個閉幕詞，就係想向我哋社會表達一個訊息：法治唔單止係法律界嘅人士同埋學者嘅事，而係我哋社會普羅大眾嘅事，更加係我哋下一代嘅事。當我哋社會上越多人有正確嘅法治意識，香港嘅法治將會係越見穩固。因此，普及法治教育係鞏固我哋香港法治最好嘅方法，亦係我哋律政司未來幾年嘅重點工作。正如行政長官喺剛發表嘅施政報告裏邊所宣布，律政司係會喺我哋司長帶領之下成立法治教育督導委員會，同我哋社會各界係一齊攜手喺社區推廣一致同埋正確嘅法治信息，務求以準確、有效、 易明嘅方式，令到市民大眾係充分理解法治。最後，我衷心感謝今日我哋各位嘉賓嘅積極支持參與，並且係感謝大會嘅各位工作人員同埋我哋律政司各位嘅同事傾力付出，令到今日嘅法治大會係帶嚟豐碩嘅成果，圓滿結束。多謝大家。
多謝副司長，請回座。咁多位嘉賓，香港法律週2022最後一個環節法治大會已經完結，而本年度嘅法律週亦都圓滿結束。喺度想謝大家掌聲，再一次多謝大家今年嘅參與，多謝你哋。Ladies and gentlemen, the Rule of Law Congress, Rule of Law and Justice for All has come to an end, and this also marks the last event of the Hong Kong Legal Week 2022. On behalf of the Department of Justice of the Hong Kong SAR of the People's Republic of China, we would like to thank all our excellent speakers and moderators for your wonderful exchange and discussions, and to all our participants here and also those watching the online broadcast. Thank you for attending the Congress and for making this a great success. We would also like to take this opportunity to express our sincere gratitude to our supporting organizations. They are the Asian Academy of International Law, the Hong Kong Bar Association, Law Asia, the Law Society of Hong Kong, Invest Hong Kong, Hong Kong International Arbitration Center, Hong Kong Mediation Accreditation Association Limited, eBram International Online Dispute Resolution Center, Hong Kong Maritime and Port Board, and the Private Wealth Management Association. 喺大家離開之前提一提大家，如果大家攞咗即時傳譯嘅耳機記住要歸還翻去到我哋門口嘅位置啦。同時，你哋嘅意見對我哋嚟講都係非常之重要㗎。咁所以麻煩大家都可以喺門口位置嗰度見到有我哋今次活動嘅嗰個問卷嘅二維碼，麻煩大家掃一掃描翻之後就填妥翻我哋今次活動嘅問卷啦。多謝大家。Before you leave, please remember to return your SI headsets at the entrance and also complete the evaluation form by scanning the QR code right at the entrance. For online participants, please fill out the online evaluation form. Last but not least, once again, thank you so much for joining us at the Hong Kong Legal Week 2022, and we hope to see you all again next year. Thank you.